Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Matthew C. Lucas, Chief Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning and welcome to the Second District Court of Appeals remote oral argument. My name is Matt Lucas. It's my pleasure to preside today along with my colleagues, Judge Tony Black and Judge Drew Atkinson. I will call the cases in the order listed on the docket. When each case is called, there will be a brief pause as you are transitioned into our virtual courtroom. After each case is completed, the participants are asked to leave the meeting and may continue to view online if they wish. As a reminder, each side is given 20 minutes for argument. If you are the appellant or petitioner, please let me know if you would like to reserve up to 5 minutes of time for rebuttal. Please unmute your microphone when you are recognized to present your argument. Thank you, and we are ready to proceed. First case that we have on the docket today is 3447 West Kennedy Boulevard, LLC and Jillian Osteen versus Tampa Bay Bar Business, LLC. Okay, so we have Mr. Mahakovich and Mr. Caldevilla. Good morning, gentlemen.
Good morning.
Okay, Mr. Mahakovich, you're up. Do you wish to reserve any time?
Yes, sir. I would like to reserve 5 minutes.
You got it.
Well, may it please the court?
Yes, sir.
I represent the petitioners 3447 West Kennedy, which I may also refer to as the landlord and its principal, Jillian Osteen. The key factual issues are not in dispute, and the real issue here is a legal one. Whether the trial court applied the wrong law when it applied Rule 4-1.10 instead of 4-1.9. Applying the wrong law is tantamount to departing from the essential requirements of law. There's no disagreement.
Can you pause real quick since you're talking about the standard?
Yes.
You don't have to lead with this, but could you at some point briefly address whether this should be an interlocutory appeal or a certiorari proceeding? I'll let you go on, but let's talk about that at some point. Thanks.
Sure. I will. And I do believe that we addressed that early on in our brief, and I can go back and address that again. But I think that we did cite some case law indicating that it should be certiorari appeal. And then we footnoted how it could also be an interlocutory appeal if the court wished to treat it that way. But I'll get to that later, if certainly if we need to. Focusing on the four key facts that would apply to Rule 4-1.9. They're all admitted by tenant in its response to the petition for writ of certiorari and in the record below. Tenant admits that in the underlying litigation, they are attacking the TBE assignments, the tenant by the entirety assignment agreements, which transferred Mr. Osteen's sole interest in the landlord company to himself and my client, Mrs. Osteen, as tenants by the entireties. That's admitted. Number two, it's admitted that those assignments were prepared by partner Cohen and associate Hendry at, rather than getting mixed up in the names of the firms, I'll just call it old firm, at their old firm when Ken Turkel and Mr. Severino were also attorneys at the old firm. That's admitted. Three, Turkel, Severino, and Hendry all left the old firm and they joined a newly formed firm that I'll call the new firm. That's admitted. At four, tenant is now represented by Turkel and Severino at the new firm over our objection, and they're attacking the work of their old firm performed while Turkel and Severino were attorneys at the old firm.
So under rule point, under 4-1.9, okay, so a lawyer, who's the lawyer in this scenario who represented another person and who now is, you're contending, cannot represent another, opposing party on the same or substantial, which lawyer?
Well, it goes through a couple of steps. Initially, it was Mr. Cohen, who represented.
Oh, we work backwards. Who's representing the tenant now?
Representing the tenant now is Turkel and Severino.
Okay, so when did they represent? Well, there's obviously the other issue about who was the prior client, but when did they represent the adverse party?
Their partner, Mr. Cohen, represented the
right,
party.
but they didn't.
They didn't directly. They were.
So why does Rule 4.4-1.9 apply if they didn't? A lawyer who has formally represented a client in a matter. Who is the lawyer who formally represented a client in a matter?
It was Cohen, and then Turkel and Severino were
the same lawyer, but that has to be the same lawyer who is prohibited from representing another person in the same or substantially related matter. So you're saying Cohen was the lawyer in the first clause of 4-1.9, but then now you're saying Turkel et al. Is the lawyer, is it? But that's the same, it's supposed to be the same lawyer, right? A lawyer who formally represented a client may not afterwards represent another person, but Cohen's not representing another person. You're accusing Turkel of representing another person.
It is Turkel, and it is that is representing the other person, and it is because you have to read 4-1.9 in conjunction with 4-1.10, which goes on.
I thought you were saying that. Maybe I'm misunderstanding your argument. You're saying that the trial court departed from the essential requirements of the law by applying 4.1 for the wrong rule.
The court used 4-1.10 by itself and said that 4-1.9 did not apply. The two need to be read together.
So are you saying it's a violation of 4-1.10 by virtue of the prohibition in 4-1.9 that is referred to within 4-1.10?
That's exactly.
So what's the prohibition?
4-1.10A imputes the disqualification to other attorneys in the firm. So the other attorneys that were.
I know, but that would only work if you would answer my question differently, which is that it was Hendry who was the individual that, because you just admitted Turkel. Well, Cohen doesn't even work for the new firm. Turkel was never a lawyer who formally represented a client. So it all obviously hinges on Hendry, right?
No, it doesn't. And that's the same trap that the trial court judge fell into. If you look at 4-110A, it says, while lawyers are associated in a firm, none of them may knowingly represent a client when any one of them practicing alone would be prohibited from doing so by Rule 4-1.9.
So who of them would be prohibited?
Cohen would have been prohibited. And so
but they don't work with Cohen anymore.
So that then becomes the issue, is what they were disqualified, no doubt. Nobody disputes that they would have been disqualified while they still worked with Cohen. They were disqualified by 4-1.10A, imputed disqualification. So the issue then is, does that imputed disqualification?
But it says while lawyers are associated in a firm.
Right. It doesn't say that goes away when they change firms. And that issue was.
But what if when they change firms, they're no longer associated in a firm?
But they're still disqualified. There's nothing in the rule that says that disqualification disappears. That imputed disqualification disappears simply because they change firms. Otherwise, attorneys could avoid disqualification all the time just by leaving and forming a new firm if they wanted to avoid a disqualification. This rule does not allow that to happen. We cited that there are very few cases directly on point to this, because very few attorneys would leave a firm and then attack the work of their prior firm for various reasons, including the fact that it could open themselves up to issues if their old firm ends up getting sued over that. But it was addressed by the Southern District of Florida in the Bancor Group case that we cited in our petition. In that case, Magistrate Torres ruled that a lawyer who was a partner in his prior firm, when the work was performed by another lawyer there, was still disqualified based on imputed knowledge, even though he left the prior firm for a new firm. So that was already dealt with there. The district court judge overruled the disqualified attorney's objection to the magistrate ruling. So it was both the magistrate and the district court judge who ruled on that.
I have a question, Mr. Malkovich. It's maybe flipping the coin over and focusing on the other side of the equation from what Judge Atkinson was talking to you about. This is what I'm bumping up against in your argument, just about the underlying attorney-client relationship that we're talking about here. Usually in these disqualification issues, when they come up, you've got a client who files an affidavit or testifies, and they say, that is my lawyer. That is who represented me. And now they're over on the other side, et cetera, et cetera. Here, I'm not seeing any affidavit or testimony from either 3447 West Kennedy Boulevard LLC or Ms. Osteen that says, Ms. Hendry was my former lawyer, or Mr. Turkel was my former lawyer, or anyone. So as that didn't happen here, or at least I'm not seeing it in the appendix, walk me through how this plays out in your analysis. And I think I would focus more on 4.1.10, but walk me through how that plays out.
There was testimony from, and it's in the transcript from the hearing, from Mr. Cohen, saying that he represented both the landlord and Mrs. Osteen. And there was also testimony from Hendry where she admitted that she did work both for the landlord and Mr. Osteen.
So the trial court then makes a factual conclusion that basically along the line of, yeah, I hear what Mr. Cohen said, and I hear what Ms. Hendry said. And based upon how the file was set up at the old firm and what they're saying, as a factual matter, I'm just not seeing it. I'm not seeing that the attorney-client relationship extended to 3447 West Kennedy Boulevard LLC, the separate LLC, or Ms. Osteen. Can we just, how do we disturb that factual finding, especially in a cert proceeding?
Well, one, you don't, of course, we think that the court got it wrong because that
Sure.
flew directly in the face of Hendry's testimony, where she says, I quote from her, says, if it was on the list of the 7 corporations that we did the conversions for, then I think it's safe to say that I did do work for that company. That's in the appendix at page 271. But putting that aside, it doesn't need to be the client. Even if the court were to accept the tenant's argument that the old firm only represented Mr. Osteen and not the landlord, despite both Hendry and Cohen's testimony to the contrary, Turkel and Severino are still disqualified under the rule because they are attacking what the rule says. They are attacking the interest of their former client, Mr. Osteen, because by signing the TBE, the tenant by the entirety document, he clearly indicated his desire and interest for the landlord entity to be owned by himself and his wife, Mrs. Osteen, as tenants by the entireties. So the rule doesn't say it has to be adverse to the landlord. It says it has to be adverse to the interest of the former client.
Well, then don't you bump up against a standing issue? Then you basically got Ms. Osteen purporting to assert a disqualification based upon the deceased Mr. Osteen, right? And that, like I said, this really it's kind of a strange one for me on disqualification cases, because, like I said, usually the client is because, again, attorney-client relationship, it's established based upon the but it is the view of the client that establishes the attorney-client relationship, and not necessarily whether the attorney says yes there was or no there wasn't, because otherwise attorneys could disclaim attorney-client relationships to get them out of hot water whenever it was convenient. So it's the client's point of view that really drives that inquiry, and we don't have that here, and it troubles me.
Well, what we have is somebody standing in the shoes of the client. Certainly, Mr. Osteen is no longer with us, so we have his widow, who stands in his shoes in various ways. She's the trustee of his trust. She's the administrator of his estate. The landlord has passed to her by tenancy of the entireties, and at least 3 ways she's standing in his shoes. But more,
but isn't that a presumption that sort of relevant to the gravamen of the dispute? I mean, we're just presuming that the former client, which you would concede at least is Mr. Osteen. We're presuming what his interests are. I mean,
well, he signed the document. His interests were for the landlord to pass from himself 100% to himself and his wife as tenants by the entireties. That was his interest as witnessed by the document itself.
Well, I mean, yeah, the third party, it's almost as if like the third party beneficiary is now standing in the shoes of the actual former client, and the sort of the subtext of the debate is whether the former client's interests were actually effectuated by the transfer that benefited the third party. I mean, I'm just, isn't it possible that it might underscore what Judge Lucas is saying? I don't want to speak for him, but the fact that he's deceased and the fact that to get to the place where you want the court to conclude, we have to presume what this deceased former client, who is not the new client, what his interests were, and then take the leap of saying, well, now the new client stands in his shoes.
We don't have to presume that because the Florida Supreme Court said otherwise. To quote from State Farm Mutual Auto Insurance Company versus KAW, it says, under certain circumstances, someone other than the client may request disqualification. So even if my current clients were not the clients, I think that they were, but even if they weren't, under certain circumstances, someone other than the client may request disqualification. So to go on with the quote says, consequently, the required analysis does not always turn on present or former representation of the party seeking disqualification. That is from a 4th DCA case, Boca Raton Regional Hospital versus Williams, which applied the Florida Supreme Court KAW case.
Mr. Mahakovich, just a heads up, you're at your 5 minutes. You're free to continue if you wish.
Okay. Well, I think that we've hit on the points that I need to for now. I will save the rest of my 5 minutes for rebuttal. Thank you.
You got it. Mr. Caldevilla.
May it please the court. Good morning, your honors. I'm Dave Caldevilla, and I represent Tampa Bay Bar Business, who's the respondent in this case, who I'll be referring to as the tenant. But let me just jump into some of the questions that have been asked by Judge Atkinson and Chief Judge Lucas. The first question you asked Judge Atkinson was about jurisdiction under the interlocutory appeal rule 9.130. And I think everyone, the parties anyway, are in agreement that there's no jurisdiction under 9.130 because that rule would allow an interlocutory appeal on a non-final order that grants or denies a motion to disqualify counsel. There's no motion to disqualify counsel in this case. As you'll recall, this was a motion actually by the tenant to substitute counsel, and the other side never filed a motion. They responded in opposition. The evidentiary hearing, the burden was placed on us as the moving party. And as I think you also know, Rule 9.130 is very strictly construed, and but there is jurisdiction under certiorari. So I think that's the most prudent course to go by here, especially since that's what's been invoked by the petitioners, and there is clearly jurisdiction there. So
can I ask you, thank you, since it's freshest in my mind at least, whether this falls under the carve out, so to speak, from the plain language of the rule, which says that under certain circumstances, someone other than the client may request disqualification. I guess that's not necessarily abrogation of the text, but you have to look at it a little creatively. So even if even if it's conceded that Ms. Osteen was not the formally represented client, that she could invoke the rule?
Okay, so that's what that case says, but was that even argued to the trial court? I don't believe so. I believe that their position was through Mr. Cohen that that the landlord and Ms. Osteen were in fact his clients. And as you noted, Judge Lucas, Ms. Henry testified, no, the client was Jean Osteen, and Jean Osteen was the client. She emphatically testified to that. Now, Mr. Hawkovich points to a portion of her testimony when she said, yes, she did some work with respect to these corporations. I'm not, that's not a quote because I don't have that right before me, but that testimony, the trial judge was in the position to conclude that that was out of context or over or outweighed by her emphatic testimony of who the client was. Now, you know, there are exceptions to where somebody else is allowed to have standing, I guess, to raise these issues. But the trial judge found that they didn't meet their burden of proof. So where are we then? I mean, you know, I think it was Judge Lucas who pointed out that, you know, certiorari case is not a great forum for challenging findings of fact. And the only way the case law allows that is when the fact-finding process is adversely affected by a departure from the essential procedural requirements. You know, we don't have any allegation of that, and there certainly wasn't any departure from any procedural requirements for an evidentiary hearing. There was notice, there was opportunity to be heard. I don't know what other procedural requirements could be invoked, but they certainly haven't invoked any. So what we have here are several dispositive findings of fact in this case, which really dispense with really all the legal arguments, but I will go ahead and hit the legal arguments as well. But, you know, and on top of that, you know, we have an incomplete record. They have not produced any of the exhibits that were presented at the hearing. And one of those exhibits is the prenuptial agreement, which gets to Judge Atkinson's point about Jean Osteen's intent. You know, they're saying, well, it was his intent to assign the landlord company to himself and his wife as joint tenants with right of survivorship. Well, the portions of the prenup that are quoted in the record, even though we don't have the prenup itself, says, hey, my companies, my property owning companies are part of this prenup, and they're not part of my will. They can't be transferred in any way, shape, or form unless that transfer occurs under the same auspices and requirements of this prenup. And maybe that's why that document hasn't been included in the record. But you cannot begin to overturn or reweigh any findings of fact that the trial judge made, especially not in this situation where the petitioners are withholding evidence from this court that was considered by the judge. So we have findings of fact that Mr. Osteen was the only client, that the petitioners have no standing to seek disqualification. The Pajitipati case, which is out of this court, explains that, hey, that is a question that hinges on the client's subjective belief. And as you noted, Judge Lucas, Ms. Osteen did not testify. And she could have. She was there. She was present. She didn't testify. Didn't want to subject herself to cross-examination, is my suspicion. Now, counsel says that, well, Ms. Osteen stands in the shoes of Mr. Osteen. Well, no, she doesn't, actually. She's being sued in her individual capacity in this case. She's not being sued in her capacity as the trustee of Mr. Osteen's estate. She's not of his trust, excuse me. She's not being sued in her capacity as the personal representative of his probate estate. She's being sued individually. She's got no shoes. She's not wearing Gene Osteen's shoes in this case. So I think that takes us to, as I said, the findings of fact are dispositive, and that's really the end of it. And so I really don't have to go any further, but I would like to go ahead and talk about the interplay of the rules, because Judge Atkinson really picked up on these points. And I think it's very clear by the questions that Judge Atkinson asked that Rule 4.4-1.9 definitely does not apply here, because that rule governs when everyone's in the same law firm. And it applies to lawyers, not law firms. You don't get to imputation of a conflict among other lawyers in the firm until you get to Rule 4-1.10. And counsel seems to be relying on 4-1.10A, which is never relied on in the trial court. Okay, it's not preserved for appeal. But let's see what it says. It says, while the lawyers are associated in the firm, which the plain text of that means we're talking, this imputation is going to take place while all the lawyers are still in the same firm. And we know that doubly sure because when you go to the comments in that rule, the comments say subdivision A operates only among the lawyers currently associated in a firm. And then it says, when a lawyer moves from one firm to another, the situation is governed by subdivisions B and C. All right. Subdivision C has not been raised in this case. It's inapplicable. Subdivision B is what we've all, my clients contended applies. In the comment for subsection B says this. Subsection B operates to disqualify the firm only when the lawyer involved has actual knowledge of relevant information protected by rules 4-1.6 and 4-1.9 B and C. Thus, if a lawyer while at one firm acquired no knowledge or information relating to a particular client of the firm, which we don't have a particular client of the firm in this case, and that lawyer later joined another firm, neither the lawyer individually nor the second firm is disqualified from representing another client in the same or related matter, even though the interests of the two clients conflict. That's a mouthful, but bottom line is that comment ends this case. It says that no, Turkel and Severino are not conflicted out. They testified they had no relationship with Gene Osteen, did not work on any of his cases. Ms. Henry, of course, is not working on this case. And Judge Huey found that she didn't get any substantially related confidential information anyway. It's also a finding of fact. So the comment to Rule 4-1.10 eviscerates their case. Now, counsel has pointed to this Bancorp case out of the Southern District of Florida, which was not cited to the trial judge because this argument of disqualifying Mr. Turkel and Mr. Severino just by virtue of them being Mr. Cohen's former partners was never raised. But the Bancorp case, what I find, there's a couple of things that I find very interesting about that case. Number one, the findings of fact in that case were just the opposite. The trial judge had an evidentiary hearing and said, I believe the client in this case. I don't believe the lawyers. The evidence is that, heck yeah, there was a former client. Yes, there was confidential information that was substantially materially related. So I find a conflict. In this case, we have findings of fact that are just the opposite. But another thing that I find interesting about the Bancorp case, it's, and a copy of it is actually in the appendix. It's in counsel's appendix, the petitioner's appendix at pages 374 and 375. If you make note of those, that those pages of the Bancorp decision, the court cited to the Bon Secours nursing home versus Seaman case, which is a second DCA case, which I did not cite in my brief. but I'd be happy to cite it as supplemental authority if you want, but it's right there at page 374 of the appendix. In that case, it was on four corners of what's going on here. You had lawyers from another firm who did not represent the client. The law firm wound down. One of the lawyers left that firm and began opposing a party who was opposing the client of the former firm. My tongue's a little twisted on that, but same facts. This court says, no, not a conflict, no disqualification. I could go through my notes here, but I feel confident that the court's read the record and read the briefs. So unless your honors have any other questions, I'm just going to rely on my brief from here on out and just request that the court deny the petition. Thank you.
Thank you, Mr. Caldavia. Mr. Mahakovich, you have your full 5 minutes.
Thank you. As far as the exhibits to the hearing not being in the record, they don't need to be because we're not relying on them. Rule 4-1.9 has 3 parts, A, B, and C, separated by the word or, so only one needs to be satisfied for attorney disqualification. Here at subpart A, which states that a lawyer who has formerly represented a client in a matter must not afterwards represent another person in the same or substantially related matter in which that person's interests are materially adverse. There's nothing in this rule that requires counsel to reveal the confidences of the former client to prevail on a motion to disqualify, particularly where there is an irrefutable presumption in Rule 4-1.9. The comments to Rule 4-1.9 provide further guidance as to the purpose of the presumption. I quote, says, a former client is not required to reveal the confidential information learned by the lawyer in order to establish a substantial risk that the lawyer has confidential information to use in the subsequent matter. A conclusion about the possession of such information may be based on the nature of services the lawyer provided the former client and information that would in ordinary practice be learned by a lawyer providing such services. That's in the comments to Rule 4-1.9. It would appear to defeat the confidential nature of the information if the former client were required to prove what confidential information was revealed to its former attorney and to, in fact, put that in the appellate record, especially when the only 4 facts that we are relying upon are stipulated to. We know that Mr. Cohen did the work for the landlord and Mr. Osteen when he, Turkel, and Severino were all part of the old firm. We know that Turkel and Severino were disqualified while they were at the old firm by imputation. And so it just comes down to the pure legal issue of whether or not that imputed disqualification goes away simply when they change law firms. That's the issue before this court.
All right. Thank you, gentlemen.
One more thing. All of this, of course, was considered by Judge Huey. I'm looking at the transcript. And he took all that into account, didn't he? Factual finding, based on the factual findings that he made.
Well, there's no dispute as to the factual findings. But our problem is that he applied the wrong law when he applied 4-1.9 and not, when he confused the two between 4-1.9 and 4-1.10.
All right. Well, thank you. Thank you, gentlemen. We'll go ahead and if you could go ahead and exit at this time, and we'll call the next case.
Thank you, Your Honors.
Thank you.
Thank you. The next case we have is Lisa McWhorter versus Event Services America, Inc. Looks like we have everyone here. And Mr. Sider, believe this is your appellant here. Would you like to reserve 5 minutes?
Yes, Your Honor. Thank you.
You got it.
Good morning, Your Honors. May it please the court. Tom Sider with Brannick Berman and Sider for the plaintiff, Lisa McWhorter. Miss McWhorter was leaving Tropicana Field after a Rays baseball game when she tripped over a shoebox-sized metal battery. It's a battery that's supposed to be used in the ballpark's metal detectors. A battery that defendant's agent had left on the floor of the ballpark's rotunda, which was a large indoor walking area. She never saw the battery before she tripped on it. Now, whether the battery was dangerous, whether defendant should have warned about that danger, those are classic jury questions. The trial court here answered those questions in the jury's stead, and we maintain that this was error. The trial court granted summary judgment on two duties that defendant owed Ms. McWhorter, but the first duty, which is the duty to maintain the property in a reasonably safe condition, that I think provides the more straightforward path to reversal, and so I'd like to start there. On this record, it's undisputed defendant owed this duty. The question is whether the record evidence, when viewed in the light most favorable to Ms. McWhorter, creates a jury question of whether the condition here was dangerous. And so I think it's worth discussing all the ways in which the battery here was dangerous. To start with, it was low to the ground. It was only 6 inches high. Ms. McWhorter's view of that battery, it was obstructed. There were people walking in front of her, which you can see on the video, and the video, I should note, it is part of the record on appeal. The video shows that Ms. McWhorter, she trips on the battery without ever having seen it. She testified to that. That's an undisputed fact. And it's also relevant here that the battery is not an object that you would expect to encounter at a baseball game. It is a metal detector battery about the size of a shoebox laying in the middle of the floor. I don't think anyone has an expectation of encountering shoebox-sized metal batteries, but you certainly would not expect one when you are leaving a baseball game and walking across the rotunda at Tropicana Field. It's just about the last place you would expect to encounter it, which is why the security guard shouldn't have left it there. And it's why the security guard, and by extension defendant, was negligent in this case. So based on all these facts, the trial court should not have entered summary judgment. That is true on either duty, but especially not on this first duty, the duty to maintain in a reasonably safe condition. What the trial court ended up doing here, though, is it ended up weighing the evidence and drawing inferences in favor of the moving party. And we know the trial court weighed the evidence because the trial court actually says as much. If you look at page 525 of the record, the court is trying to explain why this case is different than others that plaintiff cited. And the court says, I have to weigh every case on a case-by-case basis. You have to weigh the facts of the case. You have to weigh the evidence. Now, weighing the evidence is antithetical to what a trial court is supposed to be doing at the summary judgment stage. The standard here is supposed to be not what the evidence the trial court finds most persuasive, but instead whether the evidence is so one-sided that one party has to prevail as a matter of law. Now, one of the things that the trial court seemed to put a lot of stock in is the fact that Ms. McWhorter supposedly admitted, and that's the word that the court used, that she didn't use due care, and that she admitted supposedly that she could have seen the battery by, paying attention. That's not what Ms. McWhorter said during her deposition. What Ms. McWhorter said is that she could have possibly seen the battery had she been looking for it. But as she noted, she didn't see it. And she actually didn't see the battery. She didn't see it before she fell. She didn't even see it after she fell. She had to have her attorney tell her after the fact, well, what you tripped on was this metal box. And so anything that she testifies to during her deposition, when she's being asked these questions about, well, was the battery concealed? Was it in the open? Could you have seen if you were looking down? That's all just hypothetical. She's doing her best to answer the questions asked, but it's a guess because she didn't see anything that day. And I think that her
So,
testimony,
counsel-
which she's trying to get across, is distilled well on page 48 of the record. And that's when defense asks her, if you were looking in the direction of the battery, would you have seen it? And her answer is possibly, but I didn't. And so
Counsel,
she made, yes, Your Honor.
don't we have to look at whether or not it's so open and obvious that it's apparent, whether she says she saw it or not? What role does the open and obvious standard play in this?
Yes, Your Honor. Well, because we are now proceeding under, what I'm discussing now is the duty to maintain in a reasonably safe condition. The open and obvious nature of the battery doesn't play any role at the summary judgment stage. What the cases say and what this court has said many times over is that open and obvious is a consideration for the duty to warn. But when it comes to the duty to maintain, that is a factor that the jury can consider in deciding comparative negligence, but it is not something that plays a role in deciding whether the duty to maintain existed in the first place. And if we were looking at this court's precedent, I think the Conrad v. Boathouse case, which we cite in the briefs, is very similar to the facts here. And there, the plaintiff trips on a divot in a seawall. The plaintiff, after he falls, looks back, sees the divot. And during his deposition, he says, yeah, if I had been looking, I would have seen the divot. And what this court held is that testimony is not outcome determinative. There was still a question of fact actually about whether the divot was open and obvious, but also whether the defendant there failed to maintain the property in a reasonably safe condition.
What do you have to say about, I mean, I hear what you're saying about we've called it the dichotomy between failure to warn or duty to warn and duty to keep property in a reasonably safe condition. And that whether it's obvious, whether you could have seen it really doesn't play a part in the duty to keep the property in a reasonably safe condition. Except we've got this one case, I want your thoughts on it out of the first district, the Smith versus Westdale Asset Management Limited, which in the concluding paragraph, after giving us a lot of analysis that seems to relate to duty to warn, concludes that, oh, by the way, the speed bump that's been there forever in the parking lot, that's also not a reasonably unsafe condition for the property. Do you put that in the silo of speed bumps are different, or does that case, it's a dividing panel, but does that case speak to the duty to keep a property in reasonably safe condition vis-a-vis the vector of whether or not a condition is open and obvious?
Yes, Your Honor. So I think that the first district, to the extent it is holding that open and obviousness can, and something similar said in the Brookie decision, which we talk about, to the extent they're saying that an open and obvious condition can be a standalone reason for granting summary judgment on the duty to maintain, I think it is contrary to this court's precedent. But really what I think is happening in that Smith case is what Smith is saying is that there are some conditions that are so commonplace and ordinary that they just are not dangerous as a matter of law. And that's what the Florida Supreme Court said with the indoor steps. Courts have said it about speed bumps. Courts have said it about parking lot curbs. I think those are the three main examples.
So for example, if on the one extreme, if you've just got this condition like a speed bump or parking blocks, which is just everybody kind of knows they're there, it's not an unreasonably safe condition. And then the other extreme, I guess maybe you could imagine, like a convenience store that, hey, we've got a live Florida alligator here, and it's on a leash. But come on, take a look. And that would be maybe an extreme example of, yeah, you warned everybody about it, but that doesn't matter. It's open and obvious, but it's extremely dangerous, and that's a dangerous condition. And then there's a spectrum in between. And I think what you're saying is that leaving the trip hazards, like a metal shoebox size thing, in a walkway, that's not the common ordinary, it's not unreasonably dangerous. It's a potentially dangerous scenario. it's not maybe readily apparently dangerous, but it's a potentially dangerous enough that it shouldn't be given summary judgment.
Yes, Your Honor, I think that's a good encapsulation of our position here. And I think on the spectrum of ordinary conditions that you encounter in day-to-day life, a metal box on the floor in a walkway at a baseball game is pretty far on the other end of the spectrum, although somewhat short of a live alligator, which I can't top here.
That was the best I could come up with on the fly. I mean, you choose your spectrum more carefully than I did, by all means.
The other thing that's probably worth mentioning is that in those cases, the conditions you're talking about are sort of the complained of dangers are inherent in the objects themselves. Like the people are tripping on a curb. A curb has to be elevated just by its very nature. Steps have to involve changes in elevation. Same thing with speed bumps. The same cannot be said of the metal box here. The metal box here should never have been on the floor in the first place. And so what we have in this case is an uncommon item in an uncommon place. And that's what's missing in all of the cases that are cited by the defendant. And, you know, under this court's case law, even obvious conditions, even a condition that the plaintiff sees and says, I see that, if the plaintiff then trips and falls on that condition, there is still a question of fact for the jury to decide, which is whether the defendant should have anticipated, notwithstanding the supposedly obvious nature of the condition, that somebody like the plaintiff would injure themselves on it. And so even if even if this court were to accept that this was open and obvious, you know, it wouldn't resolve this question on the first duty. And I think, you know, when we look at the weight of the case law, the only case that defendant can find that is even remotely applicable to the facts here is the Brookie case involving the pallet. And in that case, though, you know, there's a dissent pointing out that it seems like this majority opinion is mostly contrary to pre-existing precedent. But the Brookie case, it turns on the fact that the pallet there was spotted by the plaintiff. The plaintiff saw it a bunch of times. The plaintiff could have easily avoided it, chose not to. That's what that case hinges on. There's another case from the first district, Moultrie, which also involves a pallet. And there, the plaintiff didn't see the pallet. And the court says, under the facts of this case, the pallet is a dangerous condition. And there's a question of fact about whether it was open and obvious. In addition to that, we've cited a lot of other cases that I think are much more on fours. There's the Mura, I'm going to say it wrong, but it's the Mura-Heinen case out of the 5th DCA that was decided very recently, which involved a low-lying furniture dolly and a video footage, just like this case. We cited cases with boxes that were left in the aisle of a grocery store, cases with a low-lying display shelf, the pallet that the plaintiff didn't see. These are all cases with similar conditions to the one here. But if anything, our case is stronger for the reason I mentioned earlier, which is at least in those cases, you're dealing with conditions that you might expect to see. At Lowe's, you might see a pallet. At a grocery store, you might see boxes. At Home Goods, you might see a furniture dolly. Here, there's no possible reason why Ms. McWhorter would expect to see a metal detector battery in the middle of the floor. That is an unexpected item in an unexpected place, and that's what makes it dangerous. If I may, I'll briefly try to touch on the open and obvious failure to warn prong here, which is the second duty. The trial court ruled there's no duty to warn here because the battery by the trial court's lights was open and obvious. There are inferences to the contrary that you can draw from this record. The battery, yes, Your Honor, sorry.
Well, I was going to say that I don't know. We got to draw inferences when, I mean, this is a unique but increasingly becoming less unique circumstance where we have, I mean, I watched the video. We have the video right there that just shows the lay of the land and shows exactly how this happened. You know, it is what it is. I mean, it's a well-lit, open area. Yeah, I don't know. There's a lot to be said about having to draw inferences one way or the other. But what do you think, given this posture, given this record?
Well, Your Honor, I do agree that there is a video, and the video shows what it shows. It's a bird's eye video. It's not taken from the perspective of Ms. McWhorter.
Yeah.
And I think, you know, the video shows people walking in front of her, which is it would be one thing if this video just showed a battery dead center in the floor and she just slowly walked towards it. But the fact is there are other people in front of her, which is an entirely predictable thing to happen at a baseball game. And she looks briefly to her right to talk to someone, and then her foot hits the battery. That again is predictable, and I don't think that you can look at that and say, well, there was no duty to warn. This would have been obvious. There's no reason you couldn't have seen it, especially when it's so low to the ground. It's just not in her field of vision at the time that she's falling. So I do think that even a video that may seem sort of unassailable can give rise to different inferences, depending on what inferences you're talking about. And here the inference is, could she, you know, would it have been open and obvious to her or to someone, a reasonable person in her position?
You're at your 5 minutes. Do you want to reserve the whole time?
Yes, sure. Thank you.
Okay, you got it. And Ms. Ryder.
Yeah, please, the court. I would like to start by responding to some of the points that were made and some of the questions asked. Well, let me first say, I represent the Applee Event Services of America. I disagree that there is some split within the DCAs, and that the appellant's argument seems to be that this court has applied a different rule in these cases than every other DCA. Because if you look at the briefs, the appellant cites cases from the first DCA, from the third DCA, from the fifth DCA. So I don't think that there is a split in the case law or a dichotomy between the cases. And I'd say even the Conrad case that the appellant relies on heavily, that case itself cited to the Brookie case. They cite the case and then they essentially apply the reasoning of Brookie, but they explain why factually this case is different. And that's not the only one. The second DCA has likewise cited the general rule, which is that the fact that something is open and obvious doesn't necessarily satisfy the duty to maintain the premises. But even the second DCA cases recognize either explicitly or implicitly that sometimes the open and obvious nature of the condition can negate the or can satisfy the duty to maintain. If you look at cases such as the Miller case, which is out of the second DCA, they say that the open and obvious nature of the condition doesn't discharge the duty to maintain if the landowner should anticipate harm despite the open and obvious nature. Then there is the Praedis case, which is cited extensively in the appellant's briefs. And the Praedis case also distinguished the Brookie case factually, but never disavowed the legal principles in Brookie, which I cited, by the way, because I think it had the clearest explanation of how the law works, which is that yes, there's two duties for a landowner. The duty to warn, but I believe the appellant's briefs don't state what that duty to warn is specifically enough, which is a duty to warn of concealed dangers that are known to the owner, but not to the invitee, and that the invitee cannot discover through the exercise of reasonable care. So it's an objective standard, which appellant basically has conceded this morning, that it's not just what that invitee knew, but what a reasonable person would have seen or known. And then there's the duty to use reasonable care in maintaining the property in reasonably safe condition. And then there's two doctrines, basically. There's the open and obvious doctrine that negates a duty to warn if the dangerous condition is known or obvious, unless the owner should anticipate harm, despite the fact that the condition's open and obvious. And then there's two situations in which the open and obvious nature of the condition does not trigger a duty to warn, and the condition itself does not violate a duty to maintain the premises. And that's one, where the open and obvious condition is not inherently dangerous, or two, where the condition is dangerous, but so open and obvious that the invitee should be expected to discover it and protect herself. On the video, which the court has said that it has watched, I would ask the court to watch it again. It took me several times viewing the video to notice this, that although appellant says that Ms. McWhorter's view was obstructed, it actually was never obstructed, really, because if you notice, the family of four is coming out from one exit or one direction, and Ms. McWhorter enters the
Isn't that a
rotunda.
jury? I mean, I'm sorry, but isn't that a jury issue?
Well, no, it's because the question is whether any reasonable jury could find that it wasn't open and obvious. Well, if you can see on the
I
video.
watched the video. I mean, I watched the video. To me, that could cut either way. I mean, you just said it yourself. I had to watch it a few times before I noticed this. I mean, if we're getting down into the weeds of what is this really showing and what inferences can be drawn from this bird's eye view video, then it just seems to me like we have moved past the summary judgment / which has now been likened to directed verdict. It seems like we've gotten past that, and we're now into, well, how should this be weighed?
Your Honor, I disagree that creates an issue of inferences. The reason that it took me a few times watching it to notice it is because I was concentrating on the 2 or 3 seconds before she tripped over the box. I wasn't concentrating on when she first walked in. But if you actually pay attention to that, you'll see that her line of sight was not obstructed by the family of four. The other thing that I noticed is that there's about 3 or 4 seconds from the point where that family clears the box. And so the family is not obstructing her view at all. The reason she didn't see the box is because, by her own admission, she was looking in a different direction. She wasn't looking where she was going. If you look back at the beginning of the video, where she's first walking into the rotunda, she wasn't looking forward there either. She was busy looking for something, fidgeting with her bag that she was carrying. Then she's looking to the right, talking to the guard. There's just no reason that she couldn't see that box. Now,
Yes, could I interrupt you for a second?
Sure.
Something occurred to me, and anyone involved in this argument can tell me I'm off base. No pun intended. But is it a subjective or an objective analysis about whether something is, open and obvious? In other words, whether this battery-sized box is open and obvious, does it depend on all these factors that are peculiar to the precise moment in which this plaintiff was walking 38 feet or whatever across this open room? I mean, in other words, does it matter whether someone briefly obstructed her view? I mean, that, someone could be walking with the iconic, grand piano workers, and then, briefly walking across anything that's otherwise open and obvious could be momentarily concealed. How
so
do we analyze this?
it is an objective standard. If you look back at the Ashcroft case, which is a Florida Supreme Court case from 1986, that case cites Prosser on torts, and it talks about that in the usual case, there is no obligation to protect the invitee against dangers which are known to him or which are so obvious and apparent that he may reasonably be expected to discover them. So way back then, the court applied an objective standard, and the appellant has agreed that it's an objective standard by arguing this morning that she didn't see it and that a reasonable person wouldn't have seen it, which I disagree with. In the
Can I
briefs,
ask a follow-up question? Sorry to
Sure.
dominate, but unless you're, well, going back to what you were discussing immediately before, the question about whether it's a factual question about whether it's open and obvious. You were pointing out two scenarios in which open and obvious is an analysis germane to the duty to maintain. Could you repeat those and then pick up where you were talking about? I just was interested in that discussion.
Sure. Where the condition is open and obvious and not inherently dangerous, or where the condition is dangerous, but it's so open and obvious that an invitee may be expected to discover it and protect herself.
And you're arguing the former, and I guess the latter only if you have to. I mean, this is not an inherently dangerous.
I think we
Maybe.
satisfy both. Yes, this is not an inherently dangerous item. And look, for the 4 people that she says obstructed her view, they all navigated around the box very easily. I mean, this is
So by the lights of that logic, then the ridiculous scenario that I put out earlier of the convenience store that keeps a live Florida alligator on a short tether, as long as they put up enough signs, as long as spotlights and it's obvious enough, hey, you can get around that fine, you can go a different way, everybody knows about it, no duty. It's not unsafe.
Well, I would say arguably, if you choose to keep a live alligator by your store's ingress and egress,
Yeah.
you have failed the duty to maintain the premises in a reasonably safe condition, right?
Okay, but your argument just now was that, hey, you can independently render something reasonably safe as long as it's open and obvious enough.
And you would expect the invitee to protect themselves.
Okay.
What's the case that comes from? Remind me. You're just quoting the language. I'm going to find it in the brief.
Well, the Brookie case discusses that. Also, the Pozanko case.
Okay, go on. I just want to reorient myself. Go ahead.
Or the Dampier case from the 5th District all cite those standards. Well, your alligator case is tricky. I'd have to think about that more, but
Well, let's focus on the facts of this case then.
right.
So you've spent a lot of time talking about how, from Ms. McWhorter's point of view to your argument, this is not an inherently dangerous condition. I mean, the flip side of that is we've got a video that shows an employee leaving a 6-inch, looks like about a 6-inch tall metal tripping hazard in an otherwise wide open public walkway. He leaves it. He does appear to have forgotten about it as he kind of goes off in another direction. Within 30 seconds, a minute of it being left there, a person does indeed trip on it, and the employee that left it there subsequently apologizes for having left it. Not enough to go to a jury.
Well, for one thing, the whole incident was about 15 seconds, maybe, from the time he left it until the time she tripped. I don't think
Doesn't that prove the other side's point? I mean,
but I don't think the issue of how long it was there changes that it was open and obvious. It does, I think, go to
one out of 5 people to pass that hazard fell over it, which is like not a great batting average, but in terms of trip and fall hazards, pretty bad, right?
Well, but you have to take into account that the other 4 people were looking where they were going.
And that's a great argument on comparative negligence, right?
Except for that, the issues on these cases is whether a reasonable person would have seen it. So let's say there was a kiosk there where they were selling T-shirts. Now, that's something you would expect in the middle of a sporting event rotunda, right?
Sure.
But the way she was walking, she just kept walking, wasn't looking where she was going, was busy talking to people off to her right. She could have easily walked to the corner of that.
And
I
I think
mean,
in that instance, your opposing counsel, I'm not going to put words in his mouth, would say, yeah, the person ran into a kiosk selling sporting goods at a sporting venue. That's having a kiosk there is not an unreasonably safe condition. This is different. An employee left a metal battery that is not terribly tall, but apparently sturdy enough that it can be a trip hazard, left it in an otherwise open walkway for not really any apparent rhyme or reason, and forgot about it. Aren't those two things just categorically different?
no, I would say
No?
no, because for one thing, we're talking now about the duty to maintain the premises in a reasonably safe condition. So the reason that the worker put that down, as you can see in the video, was to pick up a piece of paper. A piece of paper is more of a hazard because you can walk on it and slip. The box that we're talking about, 16 inches, is this wide. I mean, this is not small. And it is silver contrasted with the bright green background of the floor. I getting to another point because I'm running out of time. I don't think it matters whether the court said it was weighing the evidence or it wasn't. We're looking at the result, not the court's reasoning. And so that's what's important is the result. I want to see if I'm missing any other points I wanted to make. Oh, yes. On the issue of the security guy at a later date saying he was sorry about her falling. I think this falls under the provision in what is it? In the evidence rule that appellant cited, which find the language. Well, basically, the evidence rule says that here it's 90.4026 that a benevolent gesture expressing sympathy is not admissible, that what the person has to admit fault. And there was nothing, first of all, the appellant's testimony about this was equivocal about exactly what he said. All she could say was that he said, "I'm sorry." And appellant in their reply brief at page 5 state that an equivocal answer is not conclusive evidence. That's
I could argue to the trial judge at the summary judgment hearing?
about him saying sorry.
No, about the evidentiary rule you just cited.
I don't recall that being cited, but I can't swear to that. But I would say that the statement was just a benevolent gesture. She's a season ticket holder who's familiar with these employees, and he's sorry it happened. That's not an expression where he's saying, "I'm sorry that I reached a duty or that I was negligent or I did something wrong." He's just sorry she was hurt. So I don't think that that is proof of anything. And unless the court has any other questions, I'll rely on our briefs. Thank you, and ask the court to please affirm.
All right. Thank you. Mr. Sider.
Thank you, Your Honor. And I want to say, I think a lot of what we have heard today is effectively jury argument. And you beat me to what I was going to say, Chief Judge Lucas, which is if you have to watch the video multiple times to discover a new factual nuance, then the evidence is not so one-sided that the case can only be decided in favor of the moving party. The other thing is, I would disagree that the battery was unobstructed when Miss McWhorter walks into the rotunda, because the security guard's body is between her and the battery, and then there are people in front of her. And what this all kind of boils down to is, well, if there was a split second or a few seconds in which she could have spotted the battery, that means that it was open and obvious, and that means that the battery wasn't dangerous. And that's just, contrary.
But how does that, how is that an objective standard? I mean, the objective standard is a battery this size in the middle of an open floor with a contrasting color. Why should it matter whether during some portion of the plaintiff's traversing the open floor, her view is momentarily obstructed? How does that fit into an objective test of whether leaving something the size of a car battery with the contrasting color to the floor in the middle of a giant floor is inherently dangerous?
Yes, Your Honor. So I do agree that it's an objective standard, but it's an objective standard applied to somebody, I think, in Miss McWhorter's situation. It's not just about whether, it is reasonable generally to have this condition. It's whether somebody walking.
So in other words, you're saying because, okay, it's inherently dangerous because even if you leave a contrasting colored car battery size object in the middle of an orange floor, because people could momentarily walk in front of it and momentarily obstruct someone's view who's walked 28 feet across the floor herself, then that makes it inherently dangerous.
Yes, Your Honor, I think that is definitely part of it. And there are cases that talk about, whether the danger is reasonably foreseeable. I think it is entirely foreseeable that at a baseball game in a rotunda that empties out into the parking lot, that there will be other people walking around and that will obscure the battery's view. And so I do think that creates a question of fact as to whether it was, in fact, open and obvious. And of course, and I know that I covered
Well,
this.
I was not talking about open and obvious. I was talking about, correct me if I'm wrong, the inherently dangerous component of the analysis of when open and obvious does or does not apply to the duty to maintain.
I understand, Your Honor. So I think that we could take the position, we do not need to here, that even if this battery is put in the middle of an open floor and she trips on it and there was no one blocking her, there's still a question of fact as to whether it was a dangerous condition. It makes it a much harder case on whether it's open and obvious. But what the case law says is a landowner, or rather someone in control of the premises here, has a duty to remedy even obvious conditions if it is foreseeable that those conditions may be dangerous. And that foreseeability is what really speaks to whether a condition is dangerous or inherently.
It's like the Miller case with the missing stair rail, which everyone saw, everyone knew it wasn't there. And as the guy's helping people, apparently people get hurt a lot helping other people move.
Yes, exactly. That's exactly right, Your Honor. And that's where I was going to go next. There are cases from this court that say you can know about a condition. You can know it's there and that it's dangerous. But if the landowner is still in a position, or the operator of the premises is in a position to correct it and couldn't foresee that exact harm happening, they have a duty to do so under this first negligent duty to maintain. And so it really is a very exacting standard, and one that I think we can kind of breeze by under the facts of this case, irrespective of whether the battery is open and obvious. I think the fact that 4 people managed to walk past the battery without tripping on it doesn't really prove much of anything. There are premises cases where a condition exists, I would imagine, for months or weeks or years, and still, if somebody trips on it and a jury finds that, well, you should have foreseen that this was going to happen inevitably, that's enough to at least create a jury question on whether it was a dangerous condition. Here we have 4, as you put it, Chief Judge Lucas, we have about a 20% hit rate on this battery. And the first 4 people, I don't believe, are, even on a direct path to the battery, they walk slowly past it. I'm not sure that they even necessarily saw it. The video certainly doesn't conclusively establish that they saw the battery and then avoided it. What it looks like is they just got lucky. They happened to take a path that brought them just slightly to the side of the battery. And Ms. McWhorter was not so lucky.
Thank you, Mr. Sider.
Yes, thank you, Your Honor.
Thank you both. That that concludes this case. We'll go on and call the next case while you all exit the virtual courtroom. And the next case is Brian Schilling versus Progressive Express Insurance Company. We have Ms. Epstein.
Good morning, Your Honor.
Morning, and Mr. Vaca.
Good morning.
All right, Mr. Vaca, you are for the appellant today. Do you wish to reserve 5 minutes of time?
Yes, sir, please.
You got it.
Good
Go ahead,
morning.
sir.
May it please the court. George Vaca, Vaca Law Group, representing Brian Schilling, the plaintiff. We're here today asking the court to reverse a partial judgment with directions to enter judgment for Progressive's uninsured motorist limits of $1 million in favor of my client. And throughout the brief, I think the briefing, I think we've made it pretty clear that this case is anything but complicated. It is some fundamental principles of law that are involved. And I believe it's totally a legal question for purposes of the court's resolution. There's no real disagreement about the facts. There was an accident that resulted in Mr. Schilling's injury when he was a rear seat passenger in an Uber. The driver of the Uber was also injured in the accident.
Both cut to the chase, Mr. Vaca, as I know you like to do. The bottom line on this is that there was a $1 million UN policy which was distributed to the driver of the Uber vehicles. Is that right?
Yes.
And that's the limit of the coverage is the 1 million.
It is, but
the court entered a judgment for the amount of $0. Because the reasoning being that the policy limits have been tendered and there's no more obligation by the insurance carrier, right?
I'm certain that, well, that was what the argument was that was made by Progressive. And the argument that we made in response to that is, hey, wait a minute, we're not talking about limiting the judgment to the policy limit. If that's what we were talking about, we would have stipulated to that because that's what this court's decision in the Nationwide versus Voight case says. But what we are talking about here, I'm sorry.
We also have in the Voight case, we have the looming presence of the bad faith claim. Right?
That's present in the Voight case. Yes, it is.
And in the case before us, in our case here, there was a stipulation about trying the bad faith case after the fact. Isn't that right?
I don't know if there was a stipulation. There was the bad faith case was
abatement. That's the word I'm trying to come up with. Abatement.
Yeah, the bad faith was abated.
Right.
And
that case is still a viable case, is not? Wouldn't it be? Because it's been abated.
It theoretically is. I don't know about all the details of the bad faith to be able to give you whether it's a viable case or not. Theoretically, it still can be brought.
Right. Okay. That's what I agree with that.
So the thing that we tried to point out to the court is there's a difference between limiting the judgment to the policy limits and limiting the judgment to the available policy limits. Because once you talk about the available policy limits, now we're talking about a limitation of coverage. And as of limitation of coverage, Progressive was obligated to plead that in its answer and defenses. Now, when the amended complaint was filed in this case, the one that contained the same allegation of bad faith and seeking the uninsured motorist benefits, Progressive reserved to itself the right to amend its answers and defenses if things changed. And things changed. At the time that the amended complaint was filed, there was no other. There was another claimant, but there wasn't any other payment. There was no payment made whatsoever. That payment occurred approximately a year before this case went to trial. And so the lawyer wrote Mr. Schilling's lawyer a letter and said, hey, we paid this other person the policy limits. But then Progressive did nothing. It sat on its hands as it pertained to the exhaustion issue. and it didn't do anything about it until response to a motion for attorney's fees pursuant to a proposal for settlement that had been triggered by virtue of the $2,030,000 verdict that was rendered by the jury in favor of Mr. Schilling. And so it was our position, hey, wait a minute. Exhaustion is absolutely an affirmative defense. And we've cited this court to a third DCA case called Diamond State Insurance Company, which stands for that proposition. We've cited the court to an 11th Circuit case that stands for that proposition.
Mr. Vaca, help me out though. How is exhaustion substantively different than available coverage?
It's because it's not any different.
Okay, well then,
but that's not what that's not what.
And I don't disagree with the notion that exhaustion really isn't different than whether or not there's available coverage. But in Voight, we dealt with and issued a ruling that said, look, if there's not a dispute about the policy limits or what the available coverage is, and I don't think anybody's disputing that it's $1 million. That's all that there is, and however it gets paid, it gets paid.
There's no.
Not only are they not disputing,
there is no.
it's
There
the
is
same
no
lawyer
smart.
representing both parties, which I don't understand.
I understand, Your Honor, and that's what they wanted to make a big deal about. But the issue here is very simple, at least in my mind. Okay, if you want to come in and you say we've paid out all the limits we have, you get an affidavit from somebody who says that. I mean, what the judge made a determination based upon a letter sent by a lawyer that asserted an affirmative defense that was never pled.
Yeah, except in Voight, though, that argument was raised also. And I'm quoting from the case. Ms. Voight, quote, suggests that Nationwide had some duty to preserve this issue by defense or special pleading at an earlier stage in the proceedings. We rejected that argument, and then we granted the appellee 57-105 fee sanctions for raising it on appeal. I mean, it seems like we kind of put the hammer down on that one in Voight on this issue, didn't we?
I think the court also said that noticed that there was no waiver. That phrase is specifically in the opinion. And in this case, there absolutely was a waiver. There was a waiver because exhaustion, unlike limiting to, so in Voight, she was making the assertion that she was going to exceed the policy limits without any proof of anything pertaining to Nationwide causing her damages beyond the policy limits. And the court said, no, absent bad faith or absent a waiver, which we don't see here, you limit the judgment to the amount of the contract, and then you go forward from there. That case, at least as I read it, had nothing to do with exhaustion. It had to do with limiting the judgment to the amount of the policy limits. Okay, as stated and agreed to by the parties at the time. Here, it's a different factual scenario because some point in time from when there was an insurance policy disclosure until this case went to trial, Progressive took the position that they had exhausted the limits, and it would have been very easy to file a motion for partial summary judgment that said, hey, we've exhausted the limits. There's no coverage available. But they didn't.
You said the same lawyer representing both plaintiffs.
But, well, it was the same law firm. It was different offices of the same law firm. I don't disagree with that, Judge Black. I don't disagree with it at all. The question here, okay, and at least the way I put this, and I think I put it in the reply brief, is if I'm representing somebody in a tort case, and a lawyer sends me a letter that says, you know, your client missed the statute of limitations, and that lawyer doesn't raise as an affirmative defense the statute of limitations. And then once a verdict is rendered, the lawyer files a motion with the court saying, hey, wait a minute, the statute of limitations has expired and you should not enter judgment in favor of the plaintiff. I at least from my perspective, that's a clear waiver of the defense. And I believe this situation is analogous to that. Yeah, they wrote a letter. Yeah, they made an assertion. There's no evidence that was presented by any witness that said the limits were $1 million, we paid the $1 million. I don't think there's any question that there was $1 million that was paid, because that's what the other client received. The question here is whether or not Progressive waived its right to assert exhaustion of its policy limits. And that's where we're coming from, because the Florida Supreme Court, this court in Shaw versus Bland, the Florida Supreme Court in Jones versus Feiga, says, hey, wait a minute, you can't raise affirmative defenses for the first time in a post-trial motion. And if you've done that, you've waived it. And that's precisely what Progressive did here. So I understand that the equities may not look necessarily even, but a waiver is a waiver. And it's our position that Progressive waived that affirmative defense, which the law is pretty clear that a limitation of coverage is an affirmative defense. So that's kind of where we're at. If the court has any questions for me, I'll do my best to answer them. If not, I'll come back on rebuttal.
All right. Thank you, Mr. Vaca. You'll have your full 5 minutes.
Thank you, Your Honor.
Good morning,
Counselor?
Your Honor. Good morning, Your Honors. May it please the court, Samantha Epstein for Progressive Express Insurance Company. So basically, the issue here is that this entire endeavor is just premature, because the case where Mr. Schilling got his verdict that was preserved, the 80% of the $2 million verdict is preserved as an element of his bad faith claim that was abated. These two cases, or these two claims, are reliant on each other, as evidenced by the fact that with the amended complaint, Mr. Schilling included both the affidavit showing the $1 million in coverage, meaning he was aware that there's only $1 million in coverage, and his CRN, his civil remedy notice that he filed saying that Progressive, in bad faith, caused him damages. So we're at the point now where his bad faith claim has just finally become ripe, because liability and the amount of damages has been determined. In terms of trying to enforce a judgment for coverage, there simply is no coverage available. And I know that the judges have already talked about the Voight case, and you're very familiar with it because it comes out of this court. But in that case, this court specifically talked about the available coverage. But Mr. Schilling is not seeking damages from Progressive just for benefits. Mr. Schilling is seeking damages from Progressive based on Progressive's bad faith in handling the claim. And so their entire claim is just premature. So if they're trying to say that the $2 million is an enforceable judgment, or that it should be reduced just to $1 million as an enforceable judgment, they still can't do that beyond the $1 million policy limits, which have already been paid out. The exhaustion as an affirmative defense is not an avoidance of coverage. Progressive was never seeking to avoid coverage in general. What Progressive might do in the future, and I certainly don't want to, say the Progressive will, or, take over for the bad faith attorneys who will take over the case. But Progressive may decide that they are going to assert exhaustion as an affirmative defense to the bad faith claim. If Mr. Schilling is then successful on the bad faith claim, the $2 million, or the 80% of the $2 million verdict, comes back as part of his damages that were caused by Progressive's bad faith. But the whole point of this is that it's just premature. Even this appeal is premature. And we argued in our brief that the court should deny it as premature, because this is sort of like, even in one of the cases that was cited by the appellant, Universal Underwriters Insurance Company versus Stathopoulos, where there was a claim that was made against Universal for declaratory relief, breach of contract, and bad faith. And that was also out of this court. And the court talked about the different factors. Could the action could the cause of action disposed of by the partial summary judgment be maintained independently of the other causes of action? Were one or more parties removed from the action when the partial summary judgment was entered? Are the counts separately disposed of based on the same or different facts? The only one of those questions that can be answered affirmatively is the first one. Could the cause of action for coverage be disposed of separately from a bad faith claim? Sure. That is one way.
In fact, it kind of has to, right? Because the bad faith doesn't ripen until you get down the road.
Of course. But
Yeah,
they don't.
I'm not sure I'm seeing this is a non-appealable partial final judgment. I'm not sure I'm quite seeing that, but I hear your other arguments.
So, but just to answer the rest of the questions, the other remaining one, there was no parties removed by the verdict because there's only two parties in this case. And are the counts separately disposed, or are the counts based on the same or different facts? Well, clearly the bad faith claim has to be based on the facts, because taking the totality of the circumstances, did Progressive act in bad faith? That's the question for the bad faith claim. So it's our position that the entire endeavor, seeking attorney's fees, this appeal, all of it is premature. They don't have an enforceable judgment at this time because several paragraphs of their complaint against Progressive, count one against Progressive, were merely abated and have not been resolved. They didn't even file them as separate counts, right? It's not count one, breach of contract, count two, bad faith. They
wanted to get that bad faith. They're in a hurry to get that bad faith out there. Right?
Exactly. And they're still in a hurry to get to their attorney's fees and costs. We're not saying whether they are or are not entitled to those. They may be, depending on what happens with the bad faith case. But we think that the precedent is exceptionally clear, because Progressive has never at any point in this litigation tried to say that it is avoiding coverage duties by the exhaustion of the policy. It was never obligated to plead that as an affirmative defense. There's no waiver of it. There's nothing that can be said that could have happened legally that could extend the coverage in the policy by the additional $2 million or $1 million that Mr. Vaca says it should be extended by. The only thing that can do that, according to this court's precedent, according to precedent across Florida, is a finding of bad faith, which Mr. Schilling has alleged. And Mr. Schilling now has the obligation to prove. If this court were to reverse the trial court's order, reducing the current judgment, or reducing the current verdict to $0 based on the available policy limits, which are $0, then this court would essentially be extending the policy limits by an additional $1 million without a finding of bad faith. If the court has no more questions for me, then we're comfortable resting on our brief. We know that the court is very familiar with this case law because it comes out of this court. So.
Thank you, Ms. Epstein.
Thank you very much.
All right. Mr. Vaca, you have your full 5 minutes, sir.
Thank you, Your Honor. First, let me address the jurisdictional argument you just threw out there by saying that the appeal is premature. If the court were to look at pages 1227 and 1228 of the Fridman decision, the court specifically says and instructs that parties are free to seek review of the uninsured motorist verdict by way of a partial summary or partial final judgment under the specific rule of appellate procedure. So that argument can be tossed aside. Nobody's asking, and this is where they conflate the issues, in my opinion, in Voight and here. Nobody is asking this court to extend the limits. We've never said that, not once. What we've said is Progressive, who has the burden to plead and prove exhaustion, never did so. And because it did so, it waived that protection of its policy. That's the argument. That argument is well supported. If you go look at the St. Paul Mercury versus Kuchar case, St. Paul did the same thing. After a verdict, they tried to assert a limitation in the coverage, and the Fifth District said, nope, not so fast. That's something you needed to plead as an affirmative defense, and you waived it. So you don't walk away paying nothing. You walk away paying exactly what the trial judge said you were supposed to come away paying. The court didn't extend the coverage. It was Progressive who waived that limitation. And Progressive here waived that limitation. They never asserted it. They never told the trial judge. I mean, they issued all sorts of jury summonses to residents of Pasco County without ever telling anybody that the position they were going to take is the policy was exhausted. That was on them. So I think, again, I know that the results of waiver are definitely stark sometimes. And this would be one of those instances. But the fact of a waiver is undeniable. And the case law quite clearly is if you wait until a post-trial motion to assert this particular defense, you've waived it. And we would ask the court to rule the same way and to reverse the partial judgment with instructions on remand to enter $1 million judgment and also continue the attorney's fee hearing on the proposal for settlement.
All right. Thank you
Thank you.
both.
Thank you.
We are going to take a short recess at this time. And let's circle back. It's 11:06 on my calendar now. Let's circle back at 11:20. Hi, good morning, everyone. We'll go ahead and resume session. Our next case on the docket today is Harold Greenacre and Lisa Greenacre versus Universal Property and Casualty Insurance Company.
Good morning, Your Honor. Mark Nation on behalf of the appellants. I'll reserve 5 minutes.
All right.
So
And
I want
we have Mr. Noah there. Okay, go ahead, counsel.
to, good morning. I want to talk first about the remedy we're seeking, and then I'll get into the definitions of RCV and ACV and the definition created by the trial judge here, which deviates from those. Procedurally, we believe it was inappropriate to enter this judgment the way it was entered. But if the court were to reverse on that, we're going to be right back here with an MSJ or a DV or a jury instruction that adopts that definition of ACV that the trial court created. So I just want to deal with the merits of that issue right now. We know that ACV is the replacement cost minus depreciation. And that's in Trinidad, that's in your case, Gulf, and it's been adopted by other courts throughout the state. It is how Universal adjusted this claim. It's how they've adjusted other claims. I put 79 of their other estimates in the record evidence showing that that's how they adjust it. Yet, in this case, in paragraph 7 of the judgment that was entered, the trial court created a brand new definition. And that definition is as follows, and I'm going to quote, actual cash value is the value of the property that suffered a direct physical loss, less depreciation. That's nowhere in the case law. It's not in the statute. It's not in this policy. And it was completely made up. But that is an argument that Universal has been pushing, not in just in this case, but in cases across the state. And trial courts, very few of them adopt that, but a couple have. And I know Judge Lucas, you were on, I think, Weston and Judge Atkinson on Brito, and have dealt with these issues. This is a paid claim. Suit was filed because there was a disagreement as to the scope and price. We go to the motion in limine, and their motion was we should only be allowed to ask for ACV without matching. And we told the court we have an ACV without matching estimate. It then morphed into an evidentiary hearing where the trial court went through the estimate and said, no, with this new definition that she's adopted, this is not an ACV estimate. It is an ACV estimate. Mr. Dennis James, our general contractor, gave a detailed affidavit and said this is the actual cash value of the work that is necessary to repair the damaged property, and there's nothing for matching in this estimate. And he went through how he came up with it and developed it. And if you look line item by line item with Universal's ACV estimate, and I've just got a few I'm going to go over, we have a dumpster for $493. They have a dumpster for $316. Solar panel, ours is 8,630. Their number for
Mr. Nation, as much as I love fly specking line items of construction estimates because that's a big part of my job lately, can I lead you to an issue that I think is maybe bubbling underneath all of this?
Yes,
and I'd like to hear your thoughts on it, which is you did touch on it, which is there's a definition that we get from case law that says ACV is simply RCV less depreciation. Fair enough. But then when we read through the definitional sections of the insurance policy, we get this notion that a loss pertains to the diminution of value of something. In this case, the something is insured's house or personal property, and direct and physical modify loss and impose so as to impose the requirement that the damage be actual and that what we are focusing on is the thing that is damaged.
Yes, sir.
And so in that respect, if we were looking at actual cash value as just simply saying, what's the thing that got damaged and what was its value at the time or the moment before it was damaged, that's what you get on the front end. Then, if you go and you actually do the repairs, do the replacements, then we're going to switch this over to an RCV formulation. And that seems to jive with the definitional language. And if that does indeed jive with the definitional language, then all of this stuff about dumpsters, labor, all of it goes by the wayside, and you just focus on, okay, what was the item that was actually damaged and what was its value at the time of damage? Can you walk me through that?
Yes, I can. That definition is from the Maspons case of what a direct physical loss is. And that's the trigger for coverage that's in the perils insured against. And so that's the trigger. There has to be a direct physical loss to trigger coverage. It is not in the definitions. It's not in the policy. It's just defining direct physical loss. Then we get to the loss settlement provision. And the loss settlement provision tells us that they're going to cover that loss, a loss, at replacement costs without deduction for depreciation. But obviously, it then goes on to say that we will pay at least the actual cash value of the insured loss. And so the insured loss is talking about something else. The insured loss here, well, I'll give you an example. We have flooring. If there's a cabinet that's undamaged sitting on top of the flooring and you can't get to the flooring, it's what is the work necessary to repair the floor less depreciation.
And that's the point of departure where I'm not sure, just upon the plain language of the policy, that I'm seeing that, because clearly replacement cost value has to connote something different than actual cash value, right? I mean, because they're separate, although they're not defined in the policy, which maybe would be great if they were, but they're not. So it seems to me that replacement does indeed connote the idea of, hey, you got to do all these things in order to, as the name intuits, replace this damaged item. Whereas the actual value, actual cash value of the thing that is insured is just that. It's what is this thing? Forget like whatever it takes to actually replace it. That's great. We're just focusing on what is its actual value.
Well, the loss settlement provision clearly tells us replacement costs without holdback for depreciation. So that gets our starting point. In the same section, it says we'll initially pay at least the actual cash value of the insured loss. So where I don't know if we're disagreeing or not, is what's the insured loss? The insured loss is that replacement cost value. And the way you calculate the actual
I think that just backdoors you into RCV prior to having initiated any repairs, which is what triggers it.
Yeah,
Mr. Nation, can I ask a question that might clarify for me this dispute? The language, we insure against direct physical loss of property, that applies to both ACV and RCV, correct?
It applies to the entire Section 1 coverages, the whole thing.
Right. So that's not peculiar to RCV or to ACV. That right?
It is not. It's the trigger for coverage. Does that answer that question?
For me.
Okay. Yeah, it's the trigger that's in Section 1 at the beginning, perils insured against.
Well, let me ask you this: if it was if it applies to cabin, what ACV means, it would have to be applied to cabin what RCV means. So then RCV could also not ever include the cost to remove the solar panel in order to replace the roof tiles, correct?
100%.
Except that the provision that implicates RCV explicitly says it arises once you initiate repairs.
So not the RCV. The RCV part is at the beginning of the loss settlement, and it just says we're going to cover at replacement costs without holdback for depreciation. Then it
Mhm.
goes down to the next section and says they'll initially pay, they can pay more, but will initially pay at least the actual cash value of the insured loss. It doesn't say of the direct physical loss. The
Mm.
insured loss is the replacement cost value. The actual cash value is that less depreciation. All you got to do is look at Universal's estimate, and that proves it. Then that in their underwriting manual, their claim manual, that's how they do it. And so this would, to do it otherwise would be totally unworkable. And you would say, all right, you've got 6 pieces of flooring underneath the cabinet. What is the value of 6 pieces of flooring that's 25 years old? I don't know, $50. And then, but you got to remove the cabinet to get to it. And so you include that in the RCV, obviously. And then you back out the depreciation is the way you're supposed to do it. You back out the depreciation from that replacement cost. And in Trinidad, State Farm tried to carve out overhead and profit. And overhead and profit, and what they said in Trinidad is you can't single it out. And we quashed the third DCA's order doing so. And that's overhead and profit. Obviously, it's not damage. It's not damaged property. In golf, in the second DCA's case, we get the ACV of overhead and profit. There's just not a case that says anything different, defines ACV as anything different, and it would be totally unworkable. Totally. You
I
will
guess
have,
what I struggle with is the loss settlement provision that contemplate we will then pay any remaining amounts necessary to perform such repairs as work is performed, which obviously implicates dumpsters, labor, overhead profit, all that stuff.
okay, and I don't read it that way. The
No?
thing that's going to be paid as the work is performed is the recoverable depreciation, and that's what Universal says in its letters. I put all that in evidence. When you do the work, we will pay you we'll investigate and then pay you the recoverable depreciation. Now, with Vasquez, there's a little modifier for matching. I don't need to get into merits of whether I agree or disagree with their carve out in that case, because we put nothing for matching in our estimate. But this, to do
And
it that
I
way,
guess that's what's troubling. It seems like the way the case law is developing on this is it's almost like the courts are finding, okay, this item, this isn't part of ACV. And so that, now matching tiles, just, Ipsy Dixit, this is a one-off. We've declared this is no longer part of ACV. I mean, is that how the law is going to develop on this? That we're going to just sort of like, flashings are not part of ACV, but anything else, overhead profit, labor, all that other stuff. Yeah, that's fair game as far as ACV.
here's how it developed in the law.
Yeah.
When the third DCA ruled on Trinidad, they carved out overhead and profit as part of replacement costs until the work is performed.
Mhm.
And the Supreme Court said, don't do it. You can't do it.
Yeah.
I got a quote here from it, but that's just how that developed. And then Vasquez came out. And when Vasquez came out, they mentioned, and we all know bad facts make bad law. They got 12 tiles that they wanted replaced. They were overpaid. There was no breach of contract in Vasquez. They were overpaid. And then they wanted $70,000 for matching. And so matching is mentioned 15 times in Vasquez, and it ends with this. The Vasquez interpretation further disregards the plain language of the matching statute. And so they based it, at least in part, on the matching statute. And the statute then says, if your policy doesn't cover it, you don't have to pay it as part of the policy. That is a one-off. When Trinidad tried to do it, the Supreme Court said, no, you don't cut those things out. You can depreciate them, but you don't cut them out. When they tried to take golf out of ACV, your court said, no, you depreciate the overhead and profit. And there is no case out there that has adopted a position such as was adopted in this case. And I can't, for the life of me, figure out how it would be workable. When a homeowner gets a house damaged and they get a repair person in there, forget the litigation context. If this was affirmed, then they have a contractor who says it's going to be 50 grand to do your repairs. And these contractors don't do ACV, RCV. That's what it's going to cost. And the Supreme Court told us in Trinidad, replacement cost means what it will take to repair the property. So they submit this general contractor's report to the insurance company. The insurance company goes, well, we're not paying this. They can only be the damaged property. It's the floor that's underneath the cabinet's worth $50. The fact you got to lift up the floor to fix that, we're not paying any of that.
Until you do the repairs.
Well,
Arguably. You're at your 5 minutes, but feel free to continue.
I'll save it because I want to deal with whatever y'all dealing with my colleague. Thank you.
You got it. All right, Mr. Noel.
Good morning, Your Honors. May it please the court. My name is David Noel, and I represent the Applee Universal. Now, in this particular appeal, there were two sort of prongs to the appeal, the procedural arguments and the substantive arguments. I can't tell if Mr. Nation has withdrawn the procedural arguments, so I just want to...
Unless, I'll just, I'm not going to speak for my colleagues. Unless I hear the words, I withdraw this argument or I concede, I'm assuming they're standing by their brief. And that procedural issue bugs me, so maybe you could address that.
Sorry, Chief Judge, I've just interrupted you, but I was gonna say he mentioned at the beginning and decided to go into the other one is the way I perceived it. So
absolutely, thank you, Your Honor. So touching on the procedural arguments, in this particular case, while the motion in limine was ultimately treated as a motion for summary judgment, the plaintiffs did acquiesce to that treatment 3 different times.
Can I pause you on that? I'm sorry to interrupt you right out of the gate. Where in the order did the trial court rule, I am converting this motion in limine into a motion for summary judgment?
There's not a specific ruling to that effect, Your Honor. There was...
No, in fact, there's just this stray statement from Judge Peacock, like an oral motion for like an oral summary judgment or words to that effect. And I have no idea what inflection was in her voice, if that was incredulous or if that was, inviting. I don't know. I have no way of knowing, but I don't see anywhere. It seems like you all were just sort of talking around what this thing might be, but the order that finally gets entered before the judgment, is just an order granting a motion in limine. And somehow, I don't know, presto changeo, it's a judgment. And I still am scratching my head as to how exactly that happened, because I don't know that we got a definitive route that was ever described by the trial court.
So, Your Honor, this is an indication that the plaintiffs have not given this court a complete record and ultimately aren't really able to. There is a note within the record at page 3901 that there was apparently an emergency hearing on plaintiff's motion for reconsideration on the same day that these 2 orders came out. So presumably before they came out.
Could you repeat that page number?
Yes, 3901. And that's a response or a reply that was filed by Universal. But in that particular document, it does make note of an emergency hearing held on July 25th, 2024, and the fact that the plaintiff was able to argue their reconsideration at that hearing, but there apparently was not a court reporter. And that date of July 25th, 2024 is the same date that appears on the order granting the motion in limine and also the final judgment. So that's sort of the missing puzzle piece of how we got to that point from the motion in limine to the final judgment. I think the parties in the trial court realized that if plaintiff's evidence of damages is excluded, then they really can't prove their case at trial. So why even have a trial at this point? It should just go to the final judgment.
Well, okay, and that's where I kind of am left scratching my head, and maybe I'm just procedurally persnickety, but ordinarily, unless you have a settlement, unless you have a sanction, or unless you have a pretrial adjudication through one of the recognized rules of pretrial adjudication, you get a trial. And the trial court did not rule that it was converting, I'm not sure, I mean, put aside whether it could have, it didn't appear to rule that it was converting this into a motion for summary judgment. I don't see where it really even ruled that it was converting this into, I don't know, I guess a pre-trial motion for directed verdict before you even picked a jury. It just sort of said, well, I don't think there's going to be any evidence now, so why are we bothering? And that may be true, but you basically got one of three or four potential paths to pre-trial adjudicate a case that is otherwise ready to go to trial. And I don't see where in the order the trial court ever picked a path. And isn't that a problem in and of itself?
So, Your Honor, I would say paragraph 10 of the final judgment is explaining that. It's basically setting forth that plaintiffs don't have any proof of damages pursuant to the proper measure, which is actual cash value, and will be able to prove damages at trial.
So what is that procedurally?
Procedurally, there would have been, leading up to that, a motion for entry of judgment. And
but like, again, you only got these ways to get to a pretrial adjudication. And I'm not told which way the trial court took. And I'm not hearing from you what way the trial court took.
Your Honor, it would be present in one of the plaintiff's acquiescences to this particular procedure. I would direct the court.
Which procedure then? Okay, I mean, I don't buy. Maybe it's debatable. I'm not sure I see the acquiescence here, given the transcript that I read or what I've got before me. But okay, fine. What did they acquiesce to? What did the trial court do?
What the trial court did is treat the motion in limine as a motion for summary judgment, and that was referenced at the hearing. But even more importantly, Your Honor, on page 2024 of the record, plaintiffs themselves filed their amended response to defendant's motion for entry of judgment. So the plaintiffs themselves are saying that we move for entry of judgment based on that limine ruling, and they filed a written response opposing entry of judgment, and they have two headings in that particular response. And both of them are arguing the merits of entry of judgment.
I think your argument is the fact that nobody here can say definitively how the trial court made the leap to enter a final judgment procedurally is of no moment, because however it did, according to your reading of the record, they acquiesced to it. Is that your argument?
That's part of the argument, Your Honor. Additional argument would be that, again, there was this emergency hearing, and that record has not been provided to this court by the appellant, who would certainly have the burden of providing a full record to the court. But I think this filing by the plaintiffs, when they're responding to our motion for entry of judgment, that tells us right there that there was a motion on our side, likely in relation to that emergency motion or emergency hearing, and that was ultimately what led to the final judgment that was entered by the trial court. And that's consistent with what was said at the hearing about this being an oral motion for summary judgment, and also consistent with defense counsel having reference.
At what hearing? You said consistent with what was that at what hearing?
At the hearing on the
subsequent hearing.
Yeah, it was consistent with the hearing where we have a transcript, which was also referencing motion for summary
subsequent to the July 25th hearing, you're saying, and was referring back to what was an oral motion?
No, the motion in limine hearing was on July 18th of 2024. So that came first. That's the one we have a transcript of. And then on July 23rd.
You're saying in that hearing they referenced an oral motion for entry of judgment?
Yes, on July 18th, the trial court sort of described what Universal was arguing as an oral motion for summary judgment. The defense counsel at that July 18th hearing had mentioned an involuntary dismissal. There's no evidence.
Okay, but that's different than the court saying, Oh, yeah, we all remember when there was another hearing and there was a motion, an oral motion for entry of judgment. Is different than what you're describing, which is a trial court characterizing a motion in limine argument as essentially a motion for entry of judgment.
Correct, Judge.
Also, it can't refer forward in time to a hearing that hadn't happened yet, where you're also insinuating might have been a motion for entry of judgment.
Correct, Your Honor. It's plaintiff's own filing that refers to it as a motion for entry of judgment, which was filed on July 24th of 2024. That's located at page 2024 of the record. So that's plaintiff's own position saying, hey, there's a motion for entry of judgment here based on this limine ruling, and we're going to oppose it on the merits based on the evidence.
But there's nothing in the transcript of that July 18th motion hearing in which an oral motion for entry of judgment is made by the party itself. Right.
There's only the reference by the trial court, but the arguments that are being made by the defense counsel at that hearing are repeatedly that there's a complete lack of evidence here of the proper measure of damages. And he does refer to an involuntary dismissal. So that I would argue that's the same thing as a summary judgment. And definitely the trial court caught on to that by saying, oral motion for summary judgment. And there's even more than that, Your Honor, because
that's not a thing, right? Because there's a rule for how you do summary judgment.
There is a rule, and correct, that's an irregular procedure.
There's time periods in which you have to present filings.
Correct, Your Honor, but the case law we cited does hold that if a party does not raise that procedural defect at the hearing where it's actually happening, then it's waived and cannot be raised as an appellate argument.
Is an argument that, this is premature, this should be adjudicated at trial. Is that preserving the argument that's being made on appeal?
No, Your Honor, it wouldn't. And that particular argument that was made at the motion in limine hearing was simply that this is a damages issue, so it should be handled post-verdict. There was no argument that we're violating the Florida Rules of Civil Procedure. There was no invocation of Rule 1.530. There was nothing about you can't use a motion in limine to enter a final summary judgment.
To be clear, did you all actually advocate, Judge, we want you to convert this into a motion for summary judgment, and the judge said, okay?
That does not appear in the transcript, Your Honor. What appears is the reference to involuntary dismissal, and then the judge mentions an oral motion for summary judgment. But what's also important is that in their response to the motion in limine, Your Honors, at page 346 of the record, the plaintiffs themselves, and this is their first response to this motion in limine, they're seeing, and this is all the way back in January 3rd of 2024, the plaintiffs argue, even if Universal was correct, this is not the type of issue that is appropriate for a motion for summary judgment, but instead is a type of issue that is handled post-verdict. So right there in response to the motion in limine, plaintiffs are treating it as a motion for summary judgment. There was no issue here.
And also preserving the argument that it shouldn't be treated as a motion for summary judgment.
Well, they're referencing the timing of it. I don't think it's so much saying it shouldn't be treated as a summary judgment. It should be post-verdict because it's a damages issue. So it's more of a timing situation, but there's no argument.
They're preserving the issue that the case should not, that the motion for in limine should not be transmogrified into a dispositive motion.
I would say it's less that, Your Honor, because they didn't come out and say that. What they're referencing is more of the timing. Like, when should we address this issue? It's a damages issue, so we should address it post-verdict with the final judgment, which is not the case. They have the burden to prove damages. If they don't have any evidence of damages, they can't prove their case. They can't get to a jury, and certainly it's futile to have a trial when you have a complete lack of evidence like you have in this particular case. So in terms of the acquiescence, I mentioned it was 3 times. It was in writing twice in the response to the motion in limine that I just mentioned. It was also at the hearing. There's no mention of any of these issues about summary judgment or the Florida Rules of Civil Procedure. And then in their own response where they file saying we're responding to a motion for entry of judgment, and they also incorporated an amended motion for reconsideration. They only raised 2 substantive arguments. It wasn't until we get the judgment entered and then they come back on rehearing, and now they're invoking Rule 1.530. And they're saying, yeah, this is the wrong procedure. You can't do this procedure. The case law says that's too late. And one of the cases we cite is Head versus Sorensen from this particular case, from this court, the Second District Court of Appeal. And in that case, an argument was not raised in the written motion for summary judgment, but it was still used by the trial court as a basis for the ruling on summary judgment. And this court held that, you can't come back on rehearing and say that, hey, that was an oral motion for summary judgment. It wasn't in the written motion. That's too late. You went forward, you opposed it at the hearing on the substance, and therefore you waived that procedural irregularity. And that's what happened here, Your Honors.
Well, let's just say that it's the procedural argument is unavailing. But I don't think was touched on in quite the way I'm about to describe it, which may be the wrong way to describe it. But is that let's say that why couldn't the portion of the excised, or I guess what is this, a motion to eliminate, whatever it was, a motion to eliminate, so what was excluded, why should it have been excluded at all? Why couldn't the parties at trial argue about what portions of this document were relevant to what aspects of the claim they were speaking of? I mean, why should it have been excluded at all? Just because it couldn't have been argued that, oh no, these lines, jury, this is not ACV stuff here, so you can't why couldn't that have been the resolution of what was supposed to presumably have been an evidentiary matter?
So, Your Honor, it couldn't have been done that way because the plaintiffs didn't come forward with that particular evidence. What they did, and it's most evident in the affidavit of their damages expert, Dennis James, their response time and time again is that this entire estimate is actual cash value, and therefore it needs to go into evidence and it's proper proof of damage. They never presented testimony by affidavit or deposition from their damages expert saying, okay, you could back out these specific line items and you could reach the actual cash value number for the value of the property that suffered a direct physical loss. They didn't go down that path. They didn't make that argument, and they didn't present that evidence. So that's why it couldn't have been done, and why it was appropriate for the trial court to enter the final judgment in our favor. And that's supported by not just the policy language, which has already been discussed, the insuring agreement, which says we insure against direct physical loss to property, but also the case law. There's multiple cases supporting directly and exactly what the trial court did. The first one is Vasquez versus Citizens from the third DCA.
What about Brito? Sorry to get personal on you, but
so the issue in Brito was different than the issue we're talking about here today.
I don't disagree with that, but I'm just saying I was raising a different valence of this dispute, which is, this was a motion to eliminate. Presumably they were supposed to talk about was excluded. And, what is the ironclad evidentiary rule to exclude what ultimately would be damages? But I understand. And maybe the difference is there was no denial of coverage. Is that why?
That's definitely one of the differences with Brito here, Your Honor. There was no denial of coverage. There was an acceptance.
Because they didn't deny coverage, the insurance company can say, hey, right now we haven't denied coverage, so we should only be presenting to the jury evidence that is sterilized by the excision of anything that could stink of, replacement cost.
That was actually agreed.
If you don't do that, it's summary judgment. Just kidding. But anyway, go on.
Yes, Your Honor. So in this particular appeal, it was undisputed that we're dealing with an actual cash value case, not replacement cost value. I'd say the best example of that is page 34 of the initial brief. And a quote from that is, here the insureds did not even seek RCV like the court permitted in TIO. In this case, the insureds agreed that they would only seek the ACV amount. So it's really...
So moving right along, you've answered my question. So going back to, well, I was also trying to shunt us back into the merits, unless Judge Lucas or Judge Black want to talk about the procedural issue still. But so on the merits, leave aside Brito. I understand the distinction you're making. Can you address Mr. Nation's arguments?
Absolutely. So there's really three cases that go directly to address them. The first one is Vasquez versus Citizens. And in that particular case, the third DCA affirmed a motion in limine order from the trial court. And the third DCA's quote in that opinion is, the trial court determined that the insured loss is the property that was actually damaged. Accordingly, the trial court limited evidence of actual cash value to the property that was actually damaged. And that was affirmed. That trial court ruling was affirmed in Vasquez. That directly tells us that it has to be actual damage. It's not just repair costs that may come up in the future and are just part of the construction process. Another case we cited that's significant is People's Trust versus Gunser. And that's from the 6th DCA in 2023. And that was dealing with a tear out situation, which is a little bit different when there's a pipe leak under the slab and you have to tear out flooring to access that. And looking at that, but it's still a similar dichotomy with the ACV-RCV. And the 6th DCA held, we cannot conclude that the destruction of a concrete slab and its subsequent replacement following a water leak are direct. They are instead indirect. And that's the same situation here. These construction costs, that's not direct physical loss. These are indirectly related to the physical loss. And they only actually occur if the repairs are made. And the policy says we pay for repairs as they get made. That's what our
So I'm following. I think I'm following all that, and I, obviously read the briefs, and I'm following the arguments. I believe. What are we to make of what the ordinary meaning of replacement costs is? I see what you're saying. But is it possible that these cases or excerpts from these cases on which you're relying are importing to the terminology replacement cost a concept that would not be typically read to include, which is physically replacing things? Replacement costs, the modifier replacement in the vernacular, we're all human beings, we deal with these things in our daily lives, means a difference between what the depreciated cost is. So you're importing something into that term replacement. So replacement means what? Well, hey, what's the difference? Hey, man on the street, what is the difference between replacement costs and actual costs? Oh, okay. Well, if you had to replace it, you had to go back out to Walmart and buy a brand new one. That's what it would cost. And actual cash value is like what you could sell it on eBay. The point is, but you said, oh, no. But the word replacement includes more. It means if you have to replace something on top of the thing, then therefore that's excluded. But aren't you importing something into that word that term doesn't include?
No, Your Honor, I wouldn't say we're importing anything, because even as far back as 1954, the Florida Supreme Court in the New York Century Mutual versus Diax case was talking about actual cash value in this context. And that particular opinion, again, which is many, many decades old, it said the actual cash value is not, of course, synonymous with replacement cost or even replacement cost less depreciation.
I'm sorry, I'm going to stop you there. Can you talk about can you address the more recent case law that says actual cash value is replacement cost less depreciation instead of a 1954 case that, I don't know why there's the distinction between the Supreme Court 75 years ago and these cases, but you got to address it, don't you?
Well, yes, Judge, the more recent case law is clarifying that replacement cost minus depreciation is just the starting point and the jumping off point. And really, plaintiffs in this case have admitted that. In their initial brief, they say that in order to get actual cash value, you also have to take out matching costs. If it was just RCV minus depreciation, why are we also taking out matching costs?
Yeah, but they're just saying that because they have to deal with that case law.
Well, exactly.
Mr. Noel, just a heads up, you're going a little bit over. I'm going to give Mr. Nation a little bit extra time, but maybe it's time to answer Judge Atkinson's question.
Okay, absolutely. So that case law, the reason plaintiffs are adopting that analysis is because that case law is binding. It hasn't been overruled. It's consistent with going back, like I said, in the 1954 Diax case, And even the Trinidad case from the Florida Supreme Court more recently, it says replacement cost minus depreciation or fair market value. It's sort of indicating that actual cash value is a legal term of art, and there's different steps you have to go to calculate it. Subtracting depreciation is just your first step, but it's not your endpoint. And for the reasons argued today, Your Honors, and also in the answer brief, we would request that the court affirm the final judgment.
Thank you. Mr.
Thank you.
Nation, I'll give you
Yes, sir.
6 minutes.
Thank you, Judge. I'll address what they was talking about, and then I'll get to the procedural issues. Trinidad is clear on its definition, and the district court had cut out OMP, overridden profit. They said that's part of the replacement cost, but they also defined replacement cost, Judge Atkinson. I think this addresses what you were asking. And this is the quote: replacement cost insurance is designed to cover what it would cost to rebuild or repair the property. All right, so we have that as the definition of replacement cost. And then we have the actual cash value. And you were spot on. The only reason we're taking out matching is because Vasquez is out there and we got to deal with it for now. We'll see what happens if the Supreme Court takes it. So we take that out. What they're proposing in this definition.
Well, just pause there real quick. I mean, there's some semblance of a rationale that I'm not eschewing it. I'm just saying, I mean, that does sound like replacement cost. If you're like, well, I want what it exactly would cost for these new tiles to look just as pretty as the ones that I see in the showroom.
Not matching though. I mean, at this point, if you got,
well, I'm just saying that I'm sorry, that was my butchering of the concept of matching. But anyway, go on.
Yeah, and it would be of like, kind, and quality. That's what their policy says. You would replace you're entitled to like, kind, and quality. Then you take the depreciation out, and that's how you come up with the actual cash value. But look at, and I want to get back to the Maspons definition. That was only talking about the trigger for coverage, perils insured against. That is it. And that can't be imported to the loss settlement provision, which just deals with two things: replacement costs, actual cash value. The remaining amounts to be paid are just the recoverable depreciation and now matching. And that's what that means. And that then would bring harmony into those two provisions. If they wanted to say, we will pay at least the actual cash value of the direct physical loss, they could have said it, except the statute doesn't allow it. It's the actual cash value of the insured loss. So the real question then, what is the insured loss? It's the replacement cost of the loss. And that's what our estimate was. And again, all you got to do is look at their estimate to see how to do an ACV estimate. Look at their coverage determination letters. Look at their underwriting manual. They tell you how to do ACV. And I cannot even express how damaging it would be and how difficult it would be for homeowners inside and outside of litigation if they adopted this definition that Judge Peacock created. Actual cash value is the value of the property that suffered a direct physical loss, less depreciation. That is not in the policy. It is insured loss. Procedurally, we didn't waive anything. All this was moving quickly from 7/18 when we had the motion in limine to 7/25 when the judgment was entered. And I don't see anything about a hearing that happened on 7/25 other than in one of the defense's pleadings that says we had an opportunity. There's nothing in the docket about that at all. And we've made it clear procedurally, this was not the right thing to do, nor did they put forth any summary judgment evidence. They could not get the remedy that they wanted. And at best, their best day would be to have an evidentiary hearing after this motion in limine to go through the estimate and then take out what the court then, as a matter of law, said was not ACV. But she struck the whole thing. And then we have the judgment. And so we had to deal with that. We dealt with it quickly. I think you'll see we did not waive anything. And it was an oral motion for them. for their summary judgment at the 7/18 hearing. And that's what we're responding to when we file our motion. And then they asked for a judgment. I think they just emailed one to the judge, and we had to file a response to that. Unless there are any other questions. Thank you.
Thank you both. Interesting issues.
Thank you,
All
Judge.
right. If you all will go ahead and exit the virtual courtroom, and we will call the last case of today, which is Ray Hall, Milton Property Management LLC, Milton Property, Florida and Delaware versus In Excess 6 LLC. Do we have Mr. Rubai? There we go.
I clicked the wrong button. I'm sorry.
That's all right. Mr. Rubai, you are here for the appellants. Do you wish to reserve 5 minutes?
Yes, Your Honor. Thank you very much.
You got it.
Okay, this is an appeal of a motion to dissolve a ex parte TRO that was entered by the court. Specifically, the ex parte TRO was filed with a verified complaint for injunctive relief, and it was filed on 12/17/22, right before Christmas, and there was an emergency ex parte motion filed 12/19/2022, and then an order entered by the judge granting that with specific findings on 12/20/22. From my take, if you look at the verified complaint and you look at the ex parte emergency motion, the entire relief sought in the complaint was granted in the ex parte injunction without a hearing.
Didn't you appeal that already?
Yes, Monia Rahal appealed that.
Okay.
The ex parte ruling, it was limited to just the pleadings as set forth.
Right.
But
there's been more water under the bridge, and now you all had an evidentiary hearing.
We filed a motion.
Court gave you a couple hours.
We had a motion to dissolve that was argued. I asked the court for 3 hours or 2 hours from my side of the case. The judge then said 2 hours, but then said one for one for you, and one for the other person. And then I responded, I thought it was just you asking me, and she did ask me what did I thought I needed. I never represented to the court, nor would I, that I thought a case as complicated as this could become made only 1 hour side, especially since it was going to needed to be rebuttal on these issues. But anyway, be it as it may, the ex parte motion that was sought and granted, and which was later affirmed in its entirety, even though the oral findings do not really make the findings necessary. The hearing was on 10/2/24, which is the evidentiary hearing, and the oral pronouncements by Judge Alvarez was 11/21/24. In the meantime, I had filed a motion right after that on the 6th saying we needed more time and specifically spelling out what we needed to, because my client never got a chance to rebut or even call the witnesses rebutting what they were presenting in their case, which was that hour. And I
Well, at the evidentiary hearing, you called the other side as an adverse instead of calling your client first.
Well, that's true. But the way I understood the
You took all your time.
yeah, I did take more of my time than I should have. You're correct on that, Judge.
Took all of it, didn't it?
No, all but 10 minutes. All but 10 minutes. And, yeah, I did well, make a mistake in that regard, I would agree. Although in the past, when I've had motions to dissolve hearing, especially involving $17-20 million worth of property and complications like this, and not only that, Your Honor, my client only got to testify for 10 minutes, but more importantly, the other witnesses I had didn't get to testify, and the court completely misunderstood the status quo of the situation at the time the injunction was sought. because on the only time that possession of these properties changed was on 12/20 when that order was entered. Because before that, for years, the trusts who owned the property were the owners of the property and managing those properties. And one of the concerning things about this case, and I only have a limited amount of time at oral argument, so I want to address some things that I think are like, I don't want to use the word no-brainers, but obvious. Daniel Feynman is listed as 18 properties. He never testified. He never swore to the complaint. He never appeared at the 10-2 hearing, yet there's an injunction in his favor. On paragraphs 21 and 22, there were three evictions, paragraphs 21, 22, and 23, I should know them by heart. There were 3 evictions cited that had been filed by another party. Based on those, they asked for an injunction, and in the first part of the order, it says, not interfere with the tenants, not communicate with tenants, not file evictions. Actually, all that we were fine with because my client never filed anything as far as that goes. But then on the order to the judge, it says that the plaintiffs are prohibited, the defendants are prohibited from prosecuting or defending any action involving the 25, involving the portfolio properties, regardless of whose name they're in. So, first of all, it was an injunction violates Logan versus Logan. It shouldn't have been entered. It was drafted in fairness, what was done to Judge Arkin, and she evidently went through the roof when she found this out. They did not tell her this whole entire matter was being litigated in bankruptcy court because they rushed down in bankruptcy court. The trusts were litigating because the trust had never signed a settlement agreement with the trustee and had never stipulated for their properties to go over to the bankruptcy estate.
Well, I took a look at what was put before us from the bankruptcy proceedings.
It's all
seems,
rushed.
huh?
It's all rushed.
Well, maybe, but it seems like on the substantive merits about whether or not there was a settlement that was reached about an allegedly fraudulent transfer before the filing of the Chapter 7, it seems like bankruptcy Judge McEwen had thoughts on that and issued a ruling and was pretty clear on that. And
well,
all took issue with that before the district court, and Judge Mizell had pretty similar thoughts as what bankruptcy Judge McEwen had. So
it's before the 11th Circuit, Your Honor, right now.
Okay, all right.
The issue was before the 11th Circuit and being decided. But the important issue on this, Judge, is this. On 11/9, 11/17, Mr. Rahal went over to bankruptcy court because they had been mediating for 18 months. And he filed motions to get relief as he understood everything had to be handled in bankruptcy court. He filed motions there. They filed motions to strike that, saying it's between the trust and not him, and he can't bring this. At the same time, though, it's set for hearing for January 9th. They rushed down to state court and swear and get this injunction now claiming without joining the trust that what they asserted is that Monir Rahal and Middletown don't own the properties. That's true. They're in the name of the trust. They deliberately did in this court, and then they said we had a management agreement. Well, they knew on April 7th when they did this closing with the trustee, which was separate from my client, that they never had any estoppel letters or agreements to take possession of these properties. He was not agreeing at all with their position.
His lawyers were given notice.
Oh, no, what do you mean?
Wasn't Buddy Ford given notice?
No, none of this.
I see.
See this? What they did was very clever. What they did was this. They didn't have possessions of properties. They had these wild deeds that they had gotten from the trustee, which Old Republic wouldn't insure wild deeds anyway, so they had no insurance, and that was admitted on the witness stand. So what they did was, in order to get possession, they came to this court, to Judge Tesharkin, and made the specific allegation that Monir was there and Middleton was their management. And as a result of that, they could seize control of the properties and take the rents without revealing to the court the dispute over ownership and without bringing a quiet title action or an ejection action or anything else. Because if they had, Judge Arkin would have never entered this ex parte order. She said, you got to set this for hearing. You guys are fighting about a dispute. It's also in bankruptcy court. They're going to get a hearing. So as it was, they didn't get a hearing because they concealed the ongoing litigation in bankruptcy court. And regardless of where that ends up in the 11th Circuit, that's not the point here. The point is that there was no showing of irreparable harm to enter this injunction and to enter one stopping my client from even defending his actions or even prosecuting the actions, to strip his entire First Amendment rights and court rights. Now he's being in contempt even for appealing to the Second District Court of Appeal. That order should have never, at the 10/2/24 hearing, no evidence was presented at all as to the following things. First, nothing by the trustee, Daniel Feynman. Second, nothing for a litigation injunction. Third, nothing about prosecuting or defending. Nothing about security deposits. Nothing about accountings. Nothing about all the other things that were in this complaint. How did that get granted and why wasn't it dissolved on 10/2? If you look at Judge Alvarez's findings, she doesn't make any findings about those. They presented no evidence, and their written arguments didn't even say anything about it. Why are those still in the injunction, and why is my client facing contempt allegations for those things? And now we got other judges who see this. They go, well, this only applied to tenant evictions. It didn't apply to everything. But they wrote the injunction broadly in that one section so they could take it and use it against him and prevent him from defending himself or from even bringing up the merits of any cases that he has or any position that he has. And they did it at the 10/2 hearing. You look at the judge's pronouncements, there's no way she found injunctive relief on those other issues. I agree she reinstated the injunction, but there were no findings made whatsoever on the 4 required elements for all those other injunctions. And I presented cases that showed you cannot get an ex parte injunction on an oral contract, especially when it's disputed like this. No one even knew what the terms of the oral contract was. Rand comes in and says, oh, my reputation's been wrecked. Being wrecked by what? Taking $20 million of property for $4 million and not paying the owners anything? No, his reputation wasn't being wrecked, but no matter what, that's not an injunction. None of this stuff was a TRO, an ex parte TRO. In fact, they amended their complaint to bring all kinds of damages lawsuits afterwards. So what happened was, now we have a situation where all these properties are in their possession. The bond wasn't even set anywhere near the value, so there's only $5,000. Never had evidentiary hearing on that. So no matter how much my client loses off of the deal, he loses everything. There's no potential remedy. And he's being held in contempt for even appealing to the Second District Court of Appeal because they made this overbroad order up, which they never presented any evidence on to begin with. And when I told them those 3 evictions were filed by another third party, not my client, they then dropped the third party. And instead of dropping the relief and getting out of it, they doubled down and tried to look at the thing. Monira Hall's name's not on any of it. So, first of all, Middletown never got an appeal before. Secondly, the case law is, even though the ex parte was affirmed, they limited that to just those 3 pleadings. They did not get into, them having to prove. The case law is pretty clear. I cited it in the brief that you have to prove that hearing. In fact, Judge Lucas, I'm sure everybody is aware, every TRO involving stalking, domestic violence, they enter an ex parte all the time. And you have to have the hearing. And at that hearing, the plaintiff has to prove they're entitled to that relief. They have to prove those 4 elements with confident evidence. That's what didn't happen here. And it is true that I still think I cited the case that my client should have got a chance for cross-examination rebuttal. I found it interesting to find no tenant testified of any kind, anything was wrong. Nobody testified specifically that my client did anything. In fact, he doesn't. That's the whole irony of this whole thing. He not only didn't file those 3 eviction actions, the only thing he did was become a victim of this ridiculous bankruptcy mess. And it is a mess because the contract, which we filed later to try to show the court, the contract was between the trustee and Rand, INX 7, not my clients. The settlement agreement, which never signed, was between the trustee and my clients, and a stipulation between trustee and my clients. So bottom line is, when Mr. Rand closed on April 7th, he knew that they didn't have title to give him and that the title was messed up. But he wanted to close so bad because it's such a great deal. There was no competitive bids. There was no appraisals. He wasn't even paying the secured creditors in full, that he closed it. And this was the last key that he needed in order to now claim he had possession of the properties. And incidentally, since this has happened, there's been no depositions allowed of any of their properties. There's been no production of any discovery of what's happened to properties, what money's been made off the properties or not made off the properties. Not anything like that is available. And my client has been being held for contempt for any defense, even in appeals. If he does an appeal of an order, and now there are now, I think, 7 lawsuits filed by Rand and his various entities, maybe 8 that are pending now. And every time they come forward and say, you can't defend him, look at this order. It says right here, no prosecution or defense. You can't even bring up, you can't argue your defenses or your position or anything else. Then you applied that to Middletown too. So we think we presented ample evidence that there's no irreparable harm. If their remedy is damages, fine. They want to bring a deck action or any other action in the appropriate forum, that's one thing. But to come in here and claim an oral contract, get an injunction on it, and then take the properties and completely change possession of the properties ex parte, then affirm it with no evidence at the hearing, and not even give Mr. Rahal and the witnesses from Middletown a chance to testify, I don't think that's fair and that's right. And I cited the case that said, the court should have given some time. I agree that maybe in retrospect, I would have done a little differently, but at the end of the day, Mr. Rand's situation with the property was extremely complicated. And I think if you read his testimony closely, it was clearly a complaint about him personally, which incidentally, which I found intriguing. Mr. Rand's not even part of this lawsuit. It's this company, INX7, that has no registered agent and no ability to even bring the lawsuit under 605-113, which we never got a chance to present, except that he admitted it's true. He didn't have a registered agent for 9 years. But we're asking for the rules to be followed in this case, and for the drastic leave of injunction to be reversed, especially over all the items that are in the complaint that do not maintain the status quo, and that he has due process of law, and not because you can read their complaint, it doesn't say anything about ownership of properties versus Munir Rahal or the other trusts, or what the situation with those trusts. So the trusts weren't even joining this lawsuit, deliberately not joined.
Mr. Rubai, you are into your 5 minutes.
And thank you.
May it please the court. Oh, thank you. My name is Tracy Carlin, and I represent INXS and all the other plaintiffs below. There's a bunch of them. And we're asking the court to affirm this order denying the motion to dissolve the injunction, because the evidence that was presented at the hearing indicates exactly and by the way, a lot of what you just heard is not in the appendices at all. So it's not part of this case, not part of the record in this case. But we think that, yes, we admit we had the burden of proof to show a prima facie case to support keeping the injunction in place. And I think we did that. Rahal, however, didn't show any change in the circumstances, clear legal error, or a misapprehension of the facts by the trial court, nor did he demonstrate that the facts the trial court relied upon were untrue. And so the big issue here, I guess, is going to be this whole bankruptcy kerfuffle, which at the time that INXS got the properties, excuse me for a minute, they went to the bankruptcy court. There was a sales order that was issued by the bankruptcy court, and everybody on Rahal's side got notice of that sales order, and no one objected to it for well over 18 months. And so at the time that Mr. Rand decided to verbally terminate this oral management agreement between INXS and Mr. Rahal went to the bankruptcy court for the very first time and argued that he should have the properties and he needed to get an injunction. Well, the court said, well, you can't do it through a motion. You have to do it through an adversary proceeding. So those motions and stuff were withdrawn. And then subsequently, Judge McEwen, as Chief Judge Lucas pointed out, Judge McEwen said, hey, everybody got notice. Everybody understood what was going on. Nobody objected for more than a year. We're not going to give him any Rule 60 relief. So that the ownership of the properties is simply not in dispute in this case. And there's no way that Mr. Rahal should be able to collaterally attack a bankruptcy court order in a state court case. And that's why I think the trial court found that we have proven or at least established a prima facie case to support the injunction remaining in place. As far as the irreparable harm is concerned, Mr. Rahal has filed well over 100 lis pendens in 5 different counties. He's also filed a bunch of false construction lien claims and other false claims, which is why I think in the initial phase there was this finding that he should not be able to prosecute or defend these lawsuits because he was taking the position that he owned the property, which is a problem. And that was, let's talk about the status quo for a minute. The status quo was that InXS owned the properties and was a good faith purchaser for value under Section 363M. He terminated Rahal and demanded the return of his property. So the bankruptcy court transcript from September 8th, 2023 establishes that there's no true controversy regarding InXS's ownership of the properties. There was nothing fraudulent. Mr. Rahal was gaslighting the court. And so therefore, there's just simply no dispute about who owns his property. And because of that, we can show that we have a likely success on the merits because first, we own the property. We're good faith value for purchase, good faith purchaser for value. And Rahal actually purported to manage the properties for a full 18 months before Mr. Rand decided to terminate the contract. And it was only then that he went and asked for relief from the bankruptcy court. But Rahal ignored the termination and started telling tenants that Rand was a scammer and asking Rahal and saying that Rahal owned the properties and that the tenants needed to pay him and not InXS. And then when when some of their tenants did start paying InXS, who owns this property, that Mr. Rahal started trying to evict those tenants and give them default letters and take action against them. And then also, since the entry of the injunction, Mr. Rahal hasn't complied at all. You know, he's filing hundreds of lis pendens and claims, and he hasn't complied in one bit. And so I think the trial judge was correct to find that we met the standard for success on the merits. As to the lack of the adequate remedy and irreparable harm, again, those hundreds of lis pendens and false claims is some irreparable harm in the fact that it is clouding the title and it's impacting InXS's ability to sell the property, refinance the property, get the value of the property out of it. And also the issues with the tenants, because he was serving default notices and filing eviction actions. And the tenants were irate. They were so irate that when Mr. Rand hired that second property manager, Mr. Lowry's employees wouldn't even deal with the tenants because they were afraid of them. They were so angry. So he had to deal with them directly. So the kind of irreparable harm to InXS's and Rand's business reputation and standing and lost business opportunities are very much cannot be compensated for with money. InXS has lost the ability to work with certain lenders because of the allegations that Mr. Rahal is spreading all over the state of Florida. And without the injunction, Rahal would be free to continue this harassment campaign and wreak havoc with the tenants. And so none of this can be adequately compensated with money. And I think those are the findings that Judge Alvarez found in her judgment, as well as the public interest issues, which is the life, health, and safety issues that Mr. Lowry discovered at the properties when he went to investigate them, including electrical risks like that could cause fire, injury, and death to people. It also was in the public interest to prevent trespass and tenant harassment and interfere with tenant rights. It's also in the public interest not to have false lis pendens and false construction liens and false claims filed in the court records, in the public records. And also it's in the public interest not to have courts clogged with false eviction claims, false claims of ownership, and other things that are clogging up the court and taking over the court's resources. As to the status quo, I think I talked about that. The other issue that came up is, again, this hour-long hearing. We see that as invited error because the trial court said, hey, how much time do you need? And Mr. Rubai said, we need probably 2 or 3 hours. Court says, I'll give you 2, 1 hour per side. And then Mr. Rahal and Mr. Rubai decided to put Jamie Rand on the stand first, and they talked for 50 minutes, leaving only 10 minutes. And the court repeatedly told Mr. Rubai that you're about to run out of time. And so it was a strategic choice to put Mr. Rand on first and to waste that time there. So I think there's no need to provide any remedy at that point, particularly because at no time during the hearing did Mr. Rubai or Mr. Rahal seek a continuance and seek additional time. That only occurred after the hearing was completed. And in that motion, the trial court denied it, but that motion cannot be reviewed on appeal. It's not a 9.130 authorized appeal. So with respect to the bond amount we think is adequate, and it's been looked at a couple times by a number of different judges. This case has had 5 different judges. And in this case, because there's no dispute over who owns these properties, and it's in excess and not Mr. Rubai, he never owned the properties. He never had an interest in them. He ran and worked on or managed the properties for the trust entities before the whole settlement agreement stipulation and the sale order, which has never been overturned, never been reversed. So Rahal only argues the bond was inadequate, but at the evidentiary hearing, he didn't make any attempt to introduce evidence as to what the bond should be. And so basically we think the court reached the right result and it should be affirmed. And unless the court has any additional questions for me, I will just rest on our briefs.
All right, thank you, Ms. Carlin. Mr. Rubai.
First of all, straighten out some facts. I don't own any of the properties. She said Rubai. Number 2, the properties have never been in Munir Rahal's name either. They're in the name of 19 trusts that were intentionally not joined in the lawsuit by the plaintiffs. And secondly, at no time is there any evidence that Mr. Rahal ever spoke to any tenant at all about anything, or that anybody else communicated with any tenant. No tenant testified at the hearing, and no person testified as to any interference with any tenancy. Also, what's really important is, although there was a closing held on April 7th, my client was kept secret from him, and an objection was filed asking them to please not close this because of the problems with these documents. And Mr. Rand testified that the properties were not insurable. They canceled the insurance because these are wild deeds, meaning if you look at the chain of the title, they show the trusts owning these properties for 7 years. And suddenly on April 7th, there's a deed from a trustee. But the contract it was closed under was expressly contingent on a settlement taking place, which never took place. And Rand and everyone else knew that they were closing on property that could not be insured, and they were not getting possession of the property. At no time did that status quo ever change. Also, what counsel is leaving out is that my client was trying to follow the bankruptcy court by making the motions in the bankruptcy court the proper way. And what they did is they jumped down to the state court and asked for this relief. And then later the judge said, well, if they want to do it in the state court, I guess it can be in the state court. But they had already gotten an injunction preventing my client from litigating. I don't know what they're talking about when they said they filed those lawsuits. They're talking about the 3 lawsuits that they're saying. There isn't a lawsuit. I'm trying to think of any lawsuit that's pending by Munir Rahal related to these 25 properties at present, and I can't think of any. Okay, so I don't know what they're talking about, because at the end of the day, the trusts of the parties are involved here, and you cannot get a litigation injunction under Logan versus Logan. A bond requires an evidentiary hearing. We waited for 2 years to get this hearing, and we were supposed to get one within 5 days. And we should not have been denied the opportunity to fully address what arguments they had made. And I respectfully disagree that damage is like reputation for an individual, and his view of how it makes him look is something you can get an injunction over, a prejudgment. This injunction has to do with prohibiting my client from litigating and prohibiting and allowing them to collect all the rents on these properties and ordering him to stay away, which he has done religiously because it's been ordered by the court. But I don't see that there was any basis to ever do that, given the fact that they didn't follow any of the rules to do it, and they didn't present any evidence at the time of the hearing.
All right. There's no further questions. Thank you, Mr. Rubai. Thank you, Ms. Carlin.
Thank you,
That
Judge.
concludes our docket today, and court is adjourned.
Thank you.